My lord, my lord, it is a very urgent matter. Uh, it is I and my whole family are dispossessed on the road by the bank, by the utilization of the police authorities and the head clerk of the Howrah since 1 month. And I've already mentioned once on Friday, but it did not appear in the list, my lord.
It will not appear before the list prior to the vacation. After the vacation, please
They
come.
are on the road, my lord. They are staying.
You should have approached the tribunal and obtained some order. What will the court do over here? Surface proceeding is there. Please excuse.
May I believe, my lord, should mention this matter, my lord. On Friday, my lord, this matter was taken up. I am the intervener, my lord. And my lord, in the meantime, on Saturday, it has been that should be demolished. My lord, I am only submitting this my holding. 14 by H by 1, Chamru Singh Lane. I am that has got 2 buildings, my lord. And I am the holder.
I am not listening to you. Yes.
Extreme urgent.
I am not hearing you. Order has been passed. If you feel
Lord,
any recalling is required, you can file application. Or if appeal is preferred, please prefer.
no, my lord.
I am not.
No appeal is required, my lord. Lordship, kindly go through, my lord.
I am aware the matter has been posted on the 19th of June, if I am
My
correct.
only difficulty is this, my lord. On Saturday, it has been it has been added that that should demolish from today, you know.
It will be demolished if it's an unauthorized construction,
Lord,
nothing doing.
I am not the holder. That is a 2 buildings, my lord. I am the holder of North Western portion. That does not fall, my lord. I was not made party, my lord, to this petition, my lord.
I am not interfering. Order has been passed. Please excuse.
My lord, extreme urgent motion with regard to the installation of a petrol pump. My lord, in the NHAI guidelines says within the rural area, my lord, within 1 kilometer radius, there shall not be my lord, any petrol pump if there is any already installed. My lord, within adjacent plot holder, my lord, has been allotted by the IOCL. This is the extreme urgency, my lord. My lord, if it is operative, then my lord, I will be nowhere.
But then it cannot operate within 1 day. It will
No,
take some time. The
sanction has been
petrol pump
granted.
has to be made ready. Otherwise, it cannot be done.
No, my lord, here, my lord, we did not aware of all these things. My lord, it was construction was going on. Subsequently, the memo we have, my lord, obtained that yes, my lord, IOCL has been pleased to pass an order to that effect, the proper installation of pump, in spite of having specific guideline of the NHAI. This is the urgency, my lord.
So when do you want to move it?
22nd, my lord, there is a private respondent. I will serve it.
Very well.
I'm
Leave 22nd.
My lord, under compelling circumstances, I am mentioning before your lordship, the writ petition is pending before your lordship, which is not listed in the daily supplementary list. Despite that, my lord, competent authority has sent a notice to comply the impugned order, your lordship, within fortnight, your lordship. This is the my grave urgency to hear this writ petition, my lord. Kindly hear it within this week.
It cannot be done.
Any
Yes.
day as per your lordship.
It cannot be done.
May I be permitted to otherwise, my lord. Otherwise,
I am refusing your prayer. Yes.
Lord, may I be permitted to mention a matter for inclusion in your lordship list?
After the vacation.
Address pending is 2024, my lord.
Yes, and only 4 days prior to the vacation, you come for mentioning to get it listed. It's pending from 2024.
Oh, my lord, it was wrongly filed before.
Absolutely all right. Do you understand how it means like to mention just 4 days prior to the vacation? Come after the vacation? Yes.
My lord, may I be permitted to take leave to file one writ petition in very urgent basis, my lord. My application pending since September, my lord, 2024.
Application for what?
Application for permission to organize in a mela on a
From September?
From September 2024, and the committee has issued that letter on behalf of the private respondent on 15th of April 2025. And my application.
What do you want?
I want to move this writ petition very urgent.
When is the date of the mela?
It's 25th, my lord.
25th
of this month, my lord.
And you made application in September?
September.
Why?
2020, because there is a provision that you have to apply this before 1 year ago, after the commencing the end of the first mela, my lord.
Within 1 year you have to apply. Yeah. Within 1 year.
Within 1 year.
They have lost your application. Don't worry.
My lord,
nothing can be done. File it in the department.
My lord, the second round of litigation, my lord. The first round, my lord, made certain observations, giving a complete go.
What do you want, sir?
My lord, urgent hearing, my lord.
Yes, after the vacation.
My lord.
Or obligation, my lord.
No, sorry.
My lord, with regard
No,
to
no,
item
no, you've
number,
updated
there are
4
two
days
matters.
before the vacation. It's
Let-
absolutely
Lordship, may
possible.
I have the
with
permission to
regard
mention?
to item number
It's a matter
2174,
regarding
my lord,
RBI. RBI is violating the guidelines, and the petitioner name has been struck down from the check. It's a very urgent matter. Kindly,
Name has been struck off from
yes,
the check.
yes, your lordship.
What does this mean?
It's a name. His name, petitioner name, has been completely erased, and
The
someone has.
checkbook must be with you. How can the bank
Yes,
release
your
the
lordship.
checkbook?
I have the check copy. Bank provide me the check copy, and we have lost the FIR against that person.
Against that person means
Yes,
which
yes, your lordship.
person?
It's an unknown person.
Go,
somebody.
go before the other benches.
My
Street
lord,
court will
my
not
lord,
do
there are-
anything.
my lord, with regard to item number
interim.
217,
My lord, my lord, there are two matters.
my lord, with regard to item number 2174, my lord, may I be permitted to mention one?
Nothing.
My lord,
My lord, upgradation, new motion.
No, sorry.
My lord, item number
No,
2174,
no,
my
no.
lord.
After the vacation.
May I be
My lord, item
allowed to
number
mention a matter
2174,
which
my
took
lord.
place?
Shankar Ghosh, I humbly pray for listing of the same matters, my lord.
After the vacation, please come.
My lord, please give a date in June.
My
my
lord, with
lord.
regard to item number
Please come
2174,
after
my
the
lord.
vacation. Date will be
Lordship,
given.
may I mention a matter which took place
Non-prosecution
on
give.
Thursday?
My lord, with regard to an item of a monthly list, my lord, may I be permitted to mention, my lord?
To visit Australia.
2174.
For the
Petitioner?
petitioner is willing to visit Australia.
Yes.
Son is working there. No,
Let her visit after the vacation. No, nothing doing.
Lordship, may I be permitted to
Lordship,
mention a
item
matter?
number-
Lordship, I'm the auction purchase and I've invested almost 93 lakh rupees. Lordship, the sale certificate was also issued in my favor, but till date, no deed of conveyance has been executed. Even the possession has been handed over. Lordship, it is appearing in the monthly list of your court, Lordship, in item number 1275. Your Lordship permits for any earlier date, Your Lordship.
Yes, come on the 9th. I'll hear.
My lord, with
Lordship,
regard to item number
WPA number
2174.
4621, your lordship. WPA number 4621. It was taken up on Thursday.
Because the petitioner is a senior child, he has been removed from the medical council for a period of 2 years. And against that order, the matter was filed this court. And subsequently, just the interim order has not been given. And subsequently, we made an application before the Honorable Chief Justice for in the form of mandamus appeal. And there was the appeal, my lord has, Chief Justice has given a direction to hear out the matter before the single bench with a direction to the medical council and the state to submit the evidence in opposition within 2 weeks. So they have not filed the evidence in opposition within 2 weeks. And the matter will be mentioned before this bench within 4 weeks. So the 4 is going to be expired right now. So they have not filed the evidence in opposition. So I am the petitioner. So the matter is extremely urgent.
Extremely urgent after the vacation.
Item number 40
Only kindly seize the observation, only inclusion that has been given, liberty has been given by my lord justice.
I will include it.
Only
I will include it after the vacation. Yes.
item number
time has already been expired. So
Sir, please excuse. Yes.
Item number 40 of today's list, my lord, in earlier occasion on 16th, your lordship heard the matter under the heading extension of interim order and bank expressing his willing to refund back my amount. And my lord, today is appearing item number 40. My lord, today is the last date, my lord, for expiring the interim order.
Bring your other side.
My lord, at one.
Anytime you come. Let me see.
Non-prosecution.
Give.
Lordship,
Lordship. My lord, with regard to item number 2174 of your monthly list, my lord, may I be permitted to mention, my lord?
What you want? Where is your matter?
Lordship, this matter is in the monthly list.
Don't mention, please.
My lord,
Lordship.
please kindly, my lord, a very urgent matter. Very urgent matter. My lord, this is a senior citizen lady, my lord. She is a widow. My lord, she went to her sister's house for a kidney and my lord, cataract operation. And when that was done, my lord, her 2 sons are not allowing her to return back to her own house. The house belongs to her. It's a 3-storied house, belongs to her. They are not allowing her. Thereafter, I filed an application before the Maintenance Tribunal under the Senior Citizenship Act. And there, the Maintenance Tribunal directed my lord, the 2 sons to pay 10,000 each to the petitioner and hand over possession.
Want?
I want, my lord, I have filed this writ petition.
Why?
For
You have already.
Yes, already for implementation of that order.
No, sir.
Only,
This is
my lord,
only
otherwise,
executing court. Nothing doing.
Lordship, kindly, my lord, kindly. It is,
I am not including your matter.
then, my lord, she cannot return to her house, my lord.
Go before the
Well,
SDO.
there is no provision. The collector has,
Nothing
the
doing.
district magistrate has passed the order. My lord, there is no
The
provision.
district magistrate is not the authority. The subdivisional officer
No,
is
the
the
here
authority.
the district magistrate has passed the order because he is the
Under which provision did the
senior
district-
citizenship, the maintenance tribunal. Under the senior,
The subdivisional officer is the
No, but
authority.
here, the order was passed by dismissal. The order is there,
Check,
but
sorry.
there is no provision for which I can approach the tribunal for implementation of the order. Only this much. Only there's nothing to decide for your lordship. Only this much.
The
that
matter
attack at a
is made
sister's house.
returnable.
My lord,
The matter must be returnable.
it is
before
it is it is a new
the
motion.
matter must be returnable before the tribunal.
No, this has been disposed of.
It
But
is
it is
executed.
147 in today's list.
Not including.
Then,
and
but yes,
not upgrading.
there is lordship kindly consider.
Will you please excuse?
My lord,
Yes.
but there is no provision for implementation of the order.
Without being granted my complete diagonal period, I have been served with a notice due to which my term will expire on 21st of this month, which is day after tomorrow. Lordship gives me leave to file it today and move it tomorrow then.
No, sorry, file it in the
My lord's leave to mention, my lord.
I understand.
My lord was hearing this LOC matters, my lord, where my lord has granted us liberty. In case there is any urgency to visit outside, my lord, I can mention the matter with an application. My lord, there is a petitioner is going to visit US for a convention, my lord, which is on 3rd June. My lord, I'm just praying leave so that I can move the matter on Thursday. My lord already has granted me liberty, my lord, and there is an interim order. I'm just approaching your lordship for a formal order, my lord. That is all, my lord.
Deepa, file it. Take the number. The leave. Thursday.
Thursday, my lord, gets the lordship.
I'm seeking leave to mention a matter, my lord. May I be permitted?
Only for listed the matter.
Your Lordship, my senior had appeared in this matter virtually, but the order does not have her name. So,
Lordship, I am the senior she's speaking about, Your Lordship. I had appeared virtually, Your Lordship. I always appear before Your Lordship. This was taken up on Thursday and my name is not there, Your Lordship.
I'm mentioning a matter for arbitration.
No, don't mention.
Contempt application.
My lord, I'm only praying for release, my lord.
Why?
My lord, item number 2174, this is a hearing matter. My lord, this matter pertains to a gold loan. My lord, there is no surfacing proceedings pending, my lord. But this honorable court directed the SBI to file their affidavit in opposition and reply thereto. But no affidavit has been exchanged till now. But I am a senior citizen. But my gold loan, I need the gold back. But this is a hearing matter. But your lordship is already overburdened with matters. But may I approach the other hearing bench?
I am not releasing it prior to the vacation.
My lord, may I kindly be permitted to mention a matter for restoration, my lord? Restoration application. My lord, urgency. My lord, there is urgency, my lord. My lord, bank is deducting my pension amount, my lord.
Extension of the interim order. My lord, may I have your approval?
No.
My lord,
Nothing. No inclusions.
may I have your lordship? See petition 2020, my lord, regarding a Silka steel tap, and these petitions have become infectious. Let this matter appear.
2020 matter?
2020 matters.
I do not have determination to take up 2020 matters.
No, this appear.
I do not have determination.
Oh.
Nothing.
Lordship.
No, don't mention. Yes.
The last provision of 8th of May, lordship was restored these applications to petition. Not with regard to that young boy who has been suspended for 2 years, 8 months has already passed from our state bar council. Your lordship has directed to the this matter to be appeared. There is no direction. Restored only. Your lordship, and kindly recollect from third.
Yes, restored you have to mention, but then
after restoration.
Yes, after restoration.
Appreciate 8 months has already 2 years suspension.
Please come on the day of the reopening.
Lordship.
Call the list, please.
Lordship, may I permit to mention one matter, Lordship, which is, Lordship, this matter you have already give the liberty, Lordship, to mention regarding the.
There is a meeting to be held in the IBC matter in the margin.
Lordship.
Petitioner has to attend without leave of the court.
No, leave is not granted. Sorry.
Seeking leave to mention a matter, Lordship, for upgradation.
No, sorry. Item number 1. Item number 1 in the, yes. What is it?
Lordship, you have granted liberty to mention this matter, Lordship, regarding the Pharmacy Council election, Lordship, and fake register of the Pharmacy Council, Lordship. Respondent authority had the responsibility to file the affidavit of oppositions, but till date they are not filed.
After the vacation, please mute. Yes, what is it? Item 1?
Item over contempt application, my lord. Previous occasion, my lord, the state respondents submitted that 401 has already been initiated. And
the fate of the proceeding was to be known.
The fate of the proceeding, before that, you will also see the page number 2. Let him file a proper and correct application before the court. It's the High Court.
Yes, page number 2.
Logically, see, the violation has been done by Dr. Pallab Kumar Basu, the commissioner. I do not know whether any person who was ever appointed as the commissioner of the Kolkata Municipal Corporation, Dr. Pallab Kumar Basu. Then you logically come to page 4. Shiva Prasad Jana. Violation has been done, Dr. Pallab Kumar Basu, Pallab Kumar Das.
And contemner is Shiva Prasad Jana.
Then, my lord, he has made the Shiva Prasad Jana. He is also the commissioner of the Kolkata Municipal Corporation. And now, my lord, he is complaining of this petition, my lord. We will ask him to file a proper application before the court, my lord. And
why will the contempt application not be dismissed?
Kindly give us leave so that we can change the cost settlement. Not leave to change the cost settlement.
This is a contempt matter, sir. This is not a regular writ petition that amendments can be made in this manner. Who is leading you?
Mr. Banerjee.
Where is he?
But he is currently in code number 26.
Let him come. What is the fate of this 401?
Fate is, you also directed the executive engineer to deal with the issue, and if another construction takes place in accordance with law, there is no time limit prescribed. Pursuant to lordship's directions, my lord, the executive engineer concerned, my lord, prima facie found that another construction is there. He then referred the matter to the department concerned for processing the case under section 400. 400 proceeding has been initiated. Parties may attended the hearing.
And he is doing it himself, or this special officer is handling it?
No. Special officer is handling now, because special officer matter so far as the executive engineer concerned, my lord, he has dealt with the issue and referred the matter, prima facie finding that another construction is there.
No, that is recorded. Another is
Now it
construction
is to be dealt
detected.
with by the special officer building. It is within this domain. I cannot executive engineer.
So the executive engineer must be knowing whether it has been disposed of or not.
No, it has not been disposed. I am told, my lord, that by an order, my lord, the petitioner was asked to produce certain documents. Well, I am told, my lord, that yet to get the information whether he has submitted the required documents, my lord, before the special officer building. That direction was, my lord, was passed, my lord, long back.
Then what happened?
Hereafter, that further information I have not yet received, my lord.
Where will? Learned advocate representing the contemptor has pointed out the defects in the cause title of the contempt application. Stop. The name of the contemptor has been wrongly recorded in 2 places of the cause title. Stop. Next. The prayer has been made to dismiss the contempt application. Next. It has been brought to the notice of the court that the proceeding to deal with the unauthorized construction is still pending before the special officer building. Stop paragraph. Learned advocate representing the petitioner seeks time on such prayer released on 17th of June. The fate of the proceeding before the special officer shall be made known to the court on the adjourned date.
Item number 2, my lord, on behalf of the learned advocate, I am praying for kindly keeps after vacation the learned advocate on record.
Petitioner?
Yes, he has gone to.
On the prayer of the learned, on the prayer made on behalf of the learned advocate for the petitioner, released on 17th of June.
2 weeks after vacation.
Very well.
He has gone for medical treatment.
30th of June.
Indian Oil Corporation
No.
Item number 3.
Item number 3, I beg to appear on behalf of the petitioner.
Lordship, on the last
You
occasion-
intend to file a supplementary affidavit?
And your Lordship had directed us to file the report in the form of an affidavit. May I place the report in the form of an affidavit? Lordship, the original is with me in a sealed cover. I have not yet served my learned friend, your Lordship, because I could not without your Lordship.
What is it?
Lordship, this is a report of the ICC.
ICC? It's so voluminous.
Lordship, all the witnesses, all their statements and everything is there.
And has a copy of the supplementary been served on you?
Lordship.
Did you deal with it?
Lordship, there was no direction to lead with.
All right. Then what is the report of the ICC?
Lordship has directed us to file the report in the form of an affidavit.
Very well. Now, serve, since you have filed supplementary affidavit on behalf of the petitioner. Filed in court today is taken on record. Stop. Report of the... Which respondent will it be? Respondent numbers 1 to 5. Filed in court.
May I make one submission,
Also
Your Lordship?
be taken on record. Yes.
One submission. Lordship, the scope of the writ petition by filing of the report has now exhausted. Nothing remains in the writ petition. But if Your Lordship passes an order, we will abide by it.
I am not passing any order today. Let the report be served. Then
Lordship, the only thing is then the report has to be served in accordance with Section 13. We will serve it upon the management and the respondents and the complainant.
Whoever, whatever is to be done, do it.
Is
What is the interim order?
not to continue with this proceeding.
No, there is no interim order to that.
Yes, the committee is restrained from proceeding any further with the subject proceeding. The interim order that is subsisting in the matter is extended till 30th of June 2025 or until further order, whichever is earlier, released on 18th of June.
Lordship, that interim order, Your Lordship, by way of passing a direction upon us to file the report. Lordship, that interim order now, Your Lordship, does not subside.
I do not know what the report is. Let them also go through it. We'll see what is there. After the vacation, we'll see.
Lordship.
My lord, in item 4, I am for the writ petitioner. My lord, I am not willing to proceed further with the writ application. This is the instruction letter I have received.
Very well.
Let the writ application be dismissed as withdrawn.
Learned advocate for the petitioner submits that his client does not intend to proceed with the writ petition any further. Stop. In view of such submission, the writ petition stands dismissed as not pressed. The communication made by the petitioner to the learned advocate be retained with the records.
This is my petition, Your Lordship. I'm for the writ petitioner. I'm
Petitioner?
Fine. By way of my writ petition, I'm challenging an auction process which was held on 20th of March 2025. I'm handing up the affidavit of service apropos the last order, Your Lordship. And Your Lordship, on the last occasion, it had been pointed out to Your Lordship upfront that there was another challenge by another intending bidder in the auction process, which has already been dismissed. My contention apropos Your Lordship's query was, are there different grounds? My contention is the grounds are slightly different. The challenge in the previous writ petition was confined to material irregularity under 8.6 on account of non-publication in newspaper having wide circulation. The contention was the first two notices were published in Financial Express. The third notice was published in Echo of India. And the contention was that this perhaps does not have as wide a circulation, which the Honorable Judge has opined on and held that no, that also has sufficient circulation, and accordingly that is sufficient for compliance.
Let me see the order.
Very well. I wanted to point it out upfront so that there is
all the 3 points taken, my lord, all the 3 points taken has been covered.
Yes, I will refer to
Last official also I have handed over the copy of this order.
Is it? দেখুন তো আছে then এটা ফেরত দিয়ে দিন
2025.
the findings at 9 and 10, Your Lordship.
Probably my lord has taken my copy, which is marked. Kindly pardon me.
I have an unmarked.
First page is not. I don't see any marking.
Then with it.
তিন পেপার সাবস্টিটিউশন সব দেখে দিয়েছি, তাই তো লিখেছি আপনি করেছেন, তাহলে আমি বুঝতে পারি। লেখা থাকে কত শাস্তি।
What is your challenge?
My challenge is there is a collusion because of the scheme of
Collusion? It has been taken note of.
fraud and collusion, and I was contemporaneously communicating. This intending purchaser had not brought on record any document showing in
No, but the
contemporaneous
court has
communication.
taken note of the issue of collusion.
But the finding, Your Ladyship, subject to correction, is on the material irregularity under 8.6 at pages 9, 10, and 11. The finding is on the material irregularity regarding publication in Echo of India.
But he has not participated.
And sale took place in March 2025.
Yes, the April sale certificate was issued. And as soon as I came to know, I had filed the writ petition.
See, the court also took note of this fact. If the petitioner was genuinely interested in purchasing, it would not have
Yes.
been difficult for him to find out the details
Now,
of the auction
insofar as
sale.
my participation is concerned, I do not wish to labor. If that is your lordship's view, I will leave that to the court. But insofar as my petition is concerned, I had contemporaneously communicated and I have put those documents on record.
It doesn't matter. Please come.
Very well.
The petitioner is aggrieved by the auction sale.
And one aspect, Your Ladyship, the aspect that in case of a sole bidder scenario, the threshold for fairness, etc., are different. I'm just formally citing a decision.
Please don't, since it has been taken care of, let us not reopen issues. This will delay matters and all. See, the list is getting so heavy.
Very well. I will not labor upon. I had Your Lordship, I will not labor upon.
Auction sale conducted by the Union Bank Union Bank of India in March 2025. Paragraph. It has been submitted that the auction notice was not widely published. There has been collusion in between the successful bidder and the bank. No document. No document with regard to.
I have produced documents.
With what? Documents in support of?
Document in support of the fact that I was contemporaneously communicating offered higher value.
The petitioner had relied upon documents in support of its submission that the petitioner was ready and willing to pay a higher price than the price paid by the successful bidder. Paragraph.
I was intending to participate.
Intending bidder. The petitioner.
If something is paid, he will pay. He will.
Yes, that has been taken care of. The fact remains that the petitioner the petitioner did not participate in the auction process. Paragraph. The learned counsels representing the respondents have brought to the notice of this court an order dated 25th April 2025 passed by the court in WPO 269/2025 in the matter of set out, wherein the same auction was under challenge. The court, the grounds of challenge in the writ petition filed by Steel Armodura within brackets Supra and the instant petitioner appears to be more or less the same. The court, after hearing the parties, was pleased to dismiss the writ petition. Stop paragraph. I have perused the order passed by the court on 25th April 2025, and upon hearing the submissions made by the petitioner in the instant matter, it appears that there is no reason to come to a different finding from the one arrived at by the court in the earlier writ petition. Stop. Next. In view of the above, the writ petition fails and is hereby dismissed.
I'm deeply obliged.
Item 6.
My writ petition.
Yes.
On the last occasion, the fire has given the report.
What happened to the appeal court's order?
On that day, it was informed, my lord, that there's an appeal running in the list. And your lordship has fixed it on 19. We went and said this before the appellate court that your lordship has been pleased to fix this matter on 19. And after hearing that, though there were certain deliberation, but the Honorable Appeal Court has fixed that appeal on 21st.
All right.
In the view of the fact that your lordship
Very well.
fixed it.
My lord,
The
It
appeal
has been
on 21st.
my lord,
May I
my lord, one
proceed?
submission, my lord.
There's only thing is the appeal court has said that this should not be a ground for paying adjournment before the trial court. My lord, I have given assurance, since I am the petitioner, I have given assurance to the appellate court that I will never pray for any adjournment before the trial court.
My lord,
If your lordship allows me, I can proceed.
my lord, I appear for the respondent 16. My lord, we had preferred the appeal, my lord. The appellate court, my lord, was of the view that in view of the report filed by the fire authorities today, my lord, we were at liberty to pray if it commences to, my lord, for discontinuance of the interim order, because the report that has been filed
get it
is
thrashed
an
out before the appeal court.
my lord will
It
kindly
has been brought to the notice of the court.
my lord will
that
kindly
the Honorable
consider the
Division
report
Bench
once, my lord. 2 lines of the
has
report, my lord.
been pleased to fix up the matter on 21st. Stop.
So-
Next. In view of the above, the
lord, only-
hearing of the writ petition stands adjourned till 22nd.
My lord, could I beseech, my lord, only to have 2 lines of the report, my
2
lord.
days, go get it done before the
My
division
lord, the
bench,
appeal court
please.
adjourned it on this ground, my lord, that the matter was returnable before, my lord, today. In
Yes.
view of the report filed, my lord, could only,
Please go and settle it before
Lord,
the
the interim order needs to be extended.
my lord, let that be, it's before the appeal court.
The interim order is extended till 21st May 2025 or until further order, whichever is earlier. Get it done before the Honorable Division Bench.
My lord,
7.
could only my submission, my lord, that we are praying for, my lord, discontinuance of the order, could that be recorded, my lord? Because
Yes.
we were making that prayer. My lord, may I file a supplementary affidavit? My lord, only one thing, my lord. Supplementary affidavit, only we're in support of the report to keep that on record. We are supporting the report filed by the fire authorities. If affirmed of supplementary affidavit, my lord, could that be kept on record only, my lord?
Supplementary
Yes,
to what?
yes, my lord.
Did you file? You
affidavit?
went for the fire authority.
No,
So what
no,
supplementary
it's not an
did you
exception.
file?
It's an affidavit, my lord, whereby we make our stand clear that we are
Then
supporting.
how can it be supplementary?
It's an affidavit, my lord. I'm sorry. The term should not be a supplementary affidavit, an affidavit, only to keep our stand on record. Only to keep our stand on record. We've affirmed
And what is the nomenclature at the bat sheet? Did you write supplementary?
supplementary. We'll correct it right now.
Please do.
At this right now,
Right,
we'll,
right. All right.
well, could that be
Affidavit.
kept on the
The report
affidavit?
may be
We'll correct
taken
it
on
right.
record. It is
Exception
of
to the fire authority's
Yes.
report.
Yes.
Exception to the report. Exception of the petitioner to the report filed by the West Bengal Fire and Emergency Services is taken on record. And the affidavit, yes, all copies will be served. An affidavit of the private respondent we also written with the records.
Only thing, not kindly, not in the circumstances, kindly allow us to open the shop.
2 days. You are waiting for quite some time. Day after tomorrow, get it done before the
No, Lord,
division
please,
bench, and
please
the
appreciate.
interim order is only till the 21st. I have fixed the matter on 22nd, so you get the interim order also extended over there.
When we approached the Honorable Division Bench, the Honorable Division Bench said, why don't you go and say this to the Honorable Single Judge? So we are back before your Lordship. Otherwise, we wouldn't have troubled your Lordship.
No, see, the matter has come because it was returnable,
Right.
not for any other reason.
So for
And the
consideration of
last
this
date
report,
also,
and if not, if this
last date it was adjourned because of the pendency of the appeal.
no, not the report came on the last date, not I paid for time since the appeal was appearing on the list.
Yes,
Not,
whatever.
not if that
2 days, go over there, please. 7.
I appear for the petitioner. Well, this is against this writ has been filed against the railway's refusal to allow indents, my lord, place the empty rakes. On the last occasion, the railway sought time to take instructions. Your lordship also inquired. Your lordship remembers after they've stopped placing the rakes on my indents, they've lodged a complaint with the railway police force, and your lordship inquired as to what was the present status. My lord, I have prepared a supplementary affidavit, if I may hand over to your lordship, my lord. This gives all the summons which I have received, which my officers have received, all of which have been complied with, and we are participating in the investigation. That cannot be, my lord, which, as I said, submitted on the last occasion, a ground for refusal to allot me rakes.
Yes.
My lord, may I submit here? My lord, my learned friend is trying to make out a case that it's the case of allotment of rakes. But that is not the case, my lord. It's a case of unauthorized mining.
Unauthorized?
Unauthorized mining of crores of rupees, my lord.
Unauthorized mining?
Mining. And that already complaint has been lodged on that 13th March 2025.
How did you get to know that he was mining unauthorizedly?
My lord, we have already get several instructions and documents for that, and we want to file a report for that purpose.
No, that you filed, but tell me, how did you get the information that he was mining unauthorizedly?
My lord,
and assuming.
Yes, my lord.
Assuming he mines unauthorizedly,
My lord.
you will permit him to transport only those materials which are in accordance with the orders. It is not that if he has got a challan, if he has got an invoice, if he pays the royalty, then only you will permit him. If he does not, you don't permit. You are certainly not permitting unauthorized or illegal articles to be shipped.
My lord, the crux of this case is allotment of land was made to them, and they allotment of land, that just to mining and just for the
not the authority to allot land.
My lord, that that agreement has been done in the year 1913 or something like that, my lord.
Yes, but that must be by the land authorities, the land department, right?
My lord, that investigation has been made, and we have already we are going to just place before your lordship that during inspection, 3 numbers of illegal mining locations has been identified by the railway authorities, and that is
the railway authority is going to investigate whether somebody is mining illegally or not.
With the help of RPF, that complaint has been lodged with the RPF on 13th March 2025.
Is it within the RPF land?
My lord, that is railway land.
It's within the jurisdiction of the railway land?
My lord, that has been done, my lord, and that investigation has been done, and crores of rupees has been just found that the approximate value of the stored
What is the goods that is transported?
Stone chips, my lord.
Stone chips within the railway land?
My lord. And that is 276,531 cubic meter. That is a big issue, my lord. That's why we want to file a report, a detailed report, just to assist your lordship that just come to know all the facts of this case, your lordship.
May I address your lordship, my lord?
Where from do you excavate this?
My lord, from leases which are given to me.
Within the railway administration land?
No, my lord.
Where from?
My lord, from the adjoining areas which are and on the payment of royalty, which is everything.
That is all right, but where is the location? He says within the railway jurisdictions land?
No, my lord, I'll tell your lordship what has happened. 1925, we entered into an agreement for a railway siding. Along with the siding came certain lands. Now it is their contention, after they've stopped giving me rakes, that I have carried out illegal mining in the railways land. All the goods which I have loaded on their rakes, from whichever area, are accompanied with the challan showing mining royalty paid by the government.
Right.
Now, my lord, if their allegation is that I have mined illegally in railways land, it is for them to prosecute me. I am facing that prosecution. Today, my lord, the rakes which I am loading are with proper government challans. They do not allow loading without challans issued by the mining department. If any, assuming but not admitting, any crime has been committed by me in the past, it will result in imprisonment, fine, penalty, prosecution. But that cannot be, my lord, a ground today for stopping my business. And your lordship sees 2 representations I wrote to them. Nowhere was this allegation made. And whatever investigation they are doing, I'm fully cooperating with the investigation. It is not their case that I'm running away. I have been there since 1925. And my lord, nothing, not even one single pebble can be loaded on the railway rake without, my lord, the government challans. They do not accept any loading without the government challans. Now to come and say that this has been illegally mined is, my lord, just to harass me. The criminal investigation which they are doing will take its own course. How can they stop my business?
You can allot them rakes only if they can produce valid documents that the materials have been excavated in a proper manner.
My lord, the issue is that the land has been allotted to them and they have just making this illegal mining over there. And
no, you say allotted, and then where from the illegal mining coming? The quantity?
My lord, that's just I want to show it. So, ये map. That legal
copy भी दीजिएगा ना.
एक मिनट.
आप देख लीजिए फिर दीजिए.
ये
give a copy to him, otherwise he will not be in a position to see.
Grateful, madam.
Just 1 minute. Railway bound is there, my lord, and just new mining areas is there, and just that's why we want to put a complete report.
1 minute, let me see sketch plan showing unauthorized mining location. Railway siding, railway boundary. Which is the unauthorized mining? Old mining area, RJGS.
Sir, kindly, this is the case.
New mining area volume. Note the drawing.
Copy दीजिएगा ना, please.
How do you explain this? This sketch, how do you explain?
My lord, this marked area is that's illegal mining, my lord. That has been shown over here.
Illegal mining?
My lord.
You will permit them to transport materials only if they can produce valid documents in support of the mining.
That mining should be legal, my lord.
Certainly.
That mining should be legal.
Absolutely. You check up. If it is legal, then only you give them rakes.
That's why we have made proper investigation, my lord. And that investigation reveals that they have committed this mistake, my lord.
Yes,
Yeah.
but you will permit them to transport the materials only if the documents are there in support of the mining.
My lord.
They have been allotted certain land.
My lord.
They mine from there.
My lord.
And they mine from other places also, which is unauthorized, you say.
No, in my land, unauthorized mining is done in my land, railways land, my lord.
You have got a huge chunk of land.
My lord.
You've given half to them. The balance half he is mining, which you have not permitted.
My lord, kindly come to the just last pair of this. Okay.
The sketch map that you've shown.
That's the page number. Just
if
that I have
mining
joined
is carried out, they will catch me red-handed. It's not, my lord, digging out
that is
one.
para number 3, lordship. That new mining location that is in such and such was not visible due to the presence of heap of the stone materials. So there is a messy thing, my lord, and we have got several instructions from our just a client that we have to put on record all the evidence, my lord. And
you put it on record.
My lord.
No issue with that. But they must be having something that is legal because you have permitted them to mine.
My lord, we have permitted for legal mining,
Yes,
not illegal
yes.
mining, my lord. And they are doing illegal mining, and that is crores of rupees, my lord.
The documents at page 67, which was the challan, my lord, against these
That is
challan.
not the issue of challan. That is issue.
Supplementary affidavit filed by the petitioner in court today is taken on record. Copy of the same handed over to the learned advocate for the respondents in court today.
Supplementary diya humne.
Stuff. Learned advocate representing the Union of India submits upon instruction that the petitioner is not been allotted rakes because the petitioner is transporting illegal materials. Stop. Now, are transporting materials which are mined illegally and unauthorizedly. Stop. Paragraph. Learned, now the respondent seeks time to file affidavit in the matter. Stop. Let affidavit in opposition be prepared and circulated. By how soon?
My lord, 10 to 15 days is enough.
By 20th of June. Reply, if any, within a week thereafter. Liberty to mention the matter for hearing. immediately on conclusion of the aforesaid time period. Stop. In the meantime, the respondents shall permit the petitioner, shall allot rakes to the petitioner for transporting materials only if they are found to have been legally mined. All documents in support of the materials to be transported shall be produced by the petitioner before the authority. Stop. On satisfaction, comma, rakes will be allotted to the petitioner.
Grateful, my lord, declare.
Item number 8.
Your Lordship, I appear on behalf of respondent number 1.
But here, my lord, a proceeding was undertaken, initiated under the MSME Act.
My lord, I have a preliminary objection regarding the
Your Lordship,
maintainability
yes.
of the petition.
Is an issue pending before the Honorable Supreme Court?
No,
regarding
not
this?
because of that, my lord. Here, my lord, there's a previous round.
Yes.
We had also taken that same point. But what they are challenging in the writ petition is an arbitral award.
No. There,
Passed by the-
address the point. I
No,
conscious
if I have taken a preliminary objection,
this point first.
No, let him say what is the objection.
yes. My lord, your lordship will kindly see the prayers in the writ petition. The prayers in the writ petition, they challenge an arbitral award.
Purported order dated 12th of February 2024.
Award dated 12th of February 2024. It's an arbitral award under the Arbitration
Styled as
Conciliation
the
Act.
award. Under the Arbitration and
Under the
Conciliation
Arbitration Act. So there was a previous round in which they challenge an order passed by the same tribunal under section 16. They said that the arbitral tribunal lacked jurisdiction, inherently lacked jurisdiction. Well, order gulo din. Well, their writ petitions to dismissed, appeal carried therefrom to dismissed. So, well, so far as on the same issue that the Arbitration Act is a
one thing,
court
file your
itself,
affidavit. I
right?
will not hear you only for the reason that this award or whatever it is was passed more than a year back. So let them file their opposition. I'll hear it thereafter.
Your Lordship, one issue, Your Lordship, page 301. 301. The Honorable Division Bench, kindly have a look at the Honorable Division Bench order, Your Lordship. Page 301. Just for once. After that, we can complete the plenary, Your Lordship. But the plenary issue is whether this writ is at all maintainable or not.
Right. You take this issue. I will hear it after the vacation.
As Your Lordship pleases.
I am only submitting this, my lord. This, though, my lord, it is claimed to be an award. It is.
We'll go into the merits later on.
But today,
What
my
is
lord,
the
if they
interim
proceed in-
order?
if they proceed in execution.
Nothing doing. You came after a year. 12th of May 24. And we are what? No. This is what your prayer is.
My lord, I should tell your lordship one document to show that this has been dated, signed on 24, communicated on January 25 after 1 year.
Very well. Even that means if they're taking that also, we are in 19th of May. Ashun. The purported award dated
Kindly
12th
then, my lord, make it clear, my lord.
February 2024.
My lord, today, my lord, if it is executed, then my writ petition becomes
Oh.
infracted.
Let me see.
Well,
Acha.
I am saying this is not an order under the
2024
Arbitration Act.
is
Forum
under
non
challenge.
judice.
In the instant writ petition, stop.
It cannot
Learned
be under the
advocates
Arbitration
representing
Act.
the
But I am
respondents
supported by judgment.
raise
Say this.
a preliminary objection with regard to the maintainability of the writ petition. Stop paragraph. Prima facie, it appears that the impugned purported award is dated 12th February 2024, and at this belated stage,
Kindly see that document, how they have communicated on 25. That is my case, my lord, here.
and the
Section 34 is a
There is-
complete bar.
there is no urgency
Not an award.
to pass an interim order in this matter at this stage without deciding the issue of maintainability of the writ petition. Stop paragraph. Learned advocate for the petitioner apprehends that in the event the award is put to execution, comma, then the writ petition will become infructuous. Stop paragraph. The court is not inclined to pass any order in favor of this of the petitioners in this matter without hearing the respondents. Stop. List the matter for further consideration. Any date after the reopening?
Immediately after the kind.
Any
Ninth.
date, your lordship.
Anyway.
Ninth.
Obliged, my lord. If your lordship may
Grateful.
add only one line, my lord, that the award was served under
Very well. যেখানে
of
উপরে বললাম
2025.
যেখানে উপরে বললাম passed on এত
21st
তারিখে
January 2025.
সেখানে লিখে দিন allegedly communicated on 21st January 2025.
Obliged.
Grateful.
No, opposition. 9 June matter will be considered.
For hearing of Well, your lordship will consider the prayer for interim order on that returnable date. But
But respondents, if you all want to file something in affidavit, you can do it.
Very well.
Your lordship will file the affidavits in the meantime. and we'll
Question is that,
complete
my lord, I tell you, lordship, my lord.
get chance to
Controvert.
renew my interim order,
Yes,
the prayer for it.
Yes.
So, my lord, they can take I will address the point of maintainability.
I have kept it mainly for the issue
Correct.
of
Issue of
maintainability.
maintainability only. Great.
And my lord, your lordship, petitioner will have liberty to renew the prayer for interim order on that.
It will be open for the petitioner to renew the prayer for interim order on the next date.
Yes.
Obliged.
Now, my lord, this what they will do is that they will use this, my lord, to stop my execution. Execution is my statutory right.
Go execute.
No, the moment I go to execute, my lord,
Yes.
wherever, so this
Right.
before the district judge, if their properties are within the jurisdiction of the district judge under section 36 of the act,
Yes.
they will say, see, my challenge to the award is pending before the High Court.
It is pending. Admittedly, it is pending.
Yes.
So, no
Of
use.
course. Pending without any order.
Without any order.
Item number 1. Lordship, item number 1, I beg to appear for the private bank only. If your lordship remembers, on an earlier date, I have submitted the matter has been settled between the parties, but the only difficulty is the format.
Petitioner.
Yes, the petition.
The petitioner is not appearing.
The only thing is, if I may submit on merits, they have challenged the section 14 order before this writ court, your lordship. Kindly see their prayers once. And I'm also a private bank, your lordship. There are plethora of judgment which says writ petition against private bank is not maintainable in the eyes of law. Nothing remains, your lordship. Lordship,
Where is your notice? Show me one notice that you have given to the learned advocate for the petitioner.
by email I have served. Earlier I have served by physical mode also. Yeah, your lordship. Earlier I have served by hand also, your lordship. Kindly see. Separate notices has been served upon him.
Likunto none appears on behalf of the petitioner. Petitioners, despite notice being served by the learned advocate representing the bank. Stop. Learned advocate for the bank submits that the issue has already been settled out of court. Stop. Paragraph. The no due certificate allegedly issued by the bank on 11th March 2025 to the petitioner has been handed over in court. Stop. The same is retained with the records. Stop. As none appears for the petitioner, the writ petition stands dismissed for default.
Deeply obliged, your lordship. Item number 2.
Wait, please, your lordship. I am for the petitioner. My lord, kindly come to your lordship's order dated 20th March 2025, paragraph 5. Be that as it may, it appears that a complaint was lodged before the aforesaid authority and the same is pending without entering into the merits of the same, instant disposed of by director, executive director, retail of being the respondent 3. Instead of respondent or 3, it will be respondent 4, according to their letter. My lord, kindly see this letter. They have communicated this letter to me that it will be respondent number 3 instead of respondent 3, it will be respondent 4.
The matter has appeared in the list. বলছি has appeared in the list on mentioning ওটা তো হলো petitioner এটা হচ্ছে it has been the communicating letter dated 21st April 2025 by the learned advocate representing the oil company mentioning that no such authority as the executive director within bracket sales, West Bengal State Office exists. Stop. Request has been made to the petitioner to rectify the order with a direction upon the respondent number 4 for considering the complaint of the petitioner. Stop. In view of such information supplied to the petitioner, paragraph number 5 of the order dated 28th March 2025 is required to be corrected. Stop. In place of the respondent number 3, the respondent number 4 shall take steps. Respondent number 4 description ta dite hobe. The head of divisional office, Durgapur. Divisional office. Is directed to shall take steps to act in terms of the to act in compliance of the direction passed by the court on 28th March 2025.
And not one line, if your loss is kindly. He'll hear me. Respondent number 4 will hear the representative of the petitioner at the time of passing the order.
I cannot add anything.
My lord.
You want, in view of this letter, 3 has been changed to 4, but nothing more.
My lord. Deeply obliged. Deeply obliged.
Item number 3.
In this matter, I am appearing on behalf of the petitioner. The petitioner grievance against my lord banking ombudsman, and my lord petitioner is a small scale plastic packaging industry under MSME. So my lord, Union of India must be made a party. Your lordship,
Learned advocate for the petitioner. Petitioner submits that due to inadvertence, the Union of India was not made party in the instant writ petition. Stop. The Union of India is a proper and necessary party in the instant writ petition. Stop. The presence of the Union of India will be required for proper adjudication of the instant list. Stop. Prayer has been made to implead the Union of India as respondent. Stop. Paragraph.
Another my lord, RBI banking ombudsman, it's not correct. Only banking ombudsman. That should be, RBI should be deleted.
Achha. It has also been brought to the notice of the court that the designation of the respondent number 2 has been wrongly mentioned. Stop. Leave granted to the advocate on record of the petitioner to implead the Union of India as party respondent in the instant writ petition and serve copy of the writ petition upon the added respondent. Stop. The designation of the respondent number 2 in the cause title be amended.
My lord, matter will
List 9th.
My lord, your lordship kindly give direction, matter will appear on July any day.
July,
because
at the outset, matter is not maintainable. Cause of action 2020.
Why July?
My lord,
They have no merits.
in the meantime, to file the serve the copy of the
Serve, it can be done within 48 hours. Let it appear on 9th.
Amended cause title may also be served upon me.
Yes.
Obliged.
The amended cause title shall be served upon the learned advocate representing the respondents.
Obliged.
Grateful to your lordship.
Item number 4.
But I appear for the petition.
I appear for the respondents.
But certain provisions of the Companies Act not fall for consideration so far as their interpretation is concerned. In the writ petition as regards proceedings to be initiated thereunder. But there was an interim order passed extended from time to time. Union has decided not to file an opposition. It's on record.
Kindly will not fix
Kindly
the
not fix after,
any day
after hearing for hearing.
The third point involved, my lord, I will not take much time. Any day, my lord. Let the interim order be extended, my lord, any day.
The interim order that is subsisting in the matter is extended till 31st of July 2025 or until further order, whichever is earlier. List the matter for hearing on 20th of June 20.
Deeply obliged. Item number 5.
What is the can for? Can ta kisher jonno ache?
They filed a vacating application.
Item 5, I'm appearing for the petitioner, my lord. This was for extension of interim order. The interim order is expiring on 23rd of May. My lord, this is the matter, my lord, where pursuant to participation in an auction, my lord, the rules were changed.
After?
Lord, after participation, my lord, the rules were changed and they were deviated from the main terms and conditions of the auction. My lord. Pursuant to my lord, your lordships had called for a report, my lord, from the respondent, and my lord, there was a subsisting stay, my lord, which was operating till 23rd of May, my lord. I was humbly praying, my lord, if the interim order may be extended and a matter may be kept for hearing on any date, my lord, as convenient to your lordships. And may I be permitted to, my lord, file an affidavit of my reply to the report, my lord, the opposition filed by SEBI, my lord, in this matter.
You filed a report?
I filed an affidavit in opposition, your lordship.
Affidavit in opposition. And what is it? Is it
your lordship,
only after one day did the petitioner file the bid amount or something?
they partially made the payment on the due date, and the rest of the amount they paid after the expiry date.
But the expiry date you preponed
Your
it.
lordship, there was no modification. I also want to point out to the honorable court that the prayer for modification is not mentioned anywhere in their petition.
Suppose it is not there. Did you actually do it?
There's no modification, your lordship. The auction was conducted on 19th, and from 15 days from the 19th of November, they were supposed to make the payments. That calculation of 15 days includes the 19th day. So the day was expiring on 3rd December. The same was duly intimated to them also via email dated 19 November only. They had full knowledge, ample time and opportunity to make the payment. They only made payment of the balance amount, but the poundage fee, for some reason, they submitted beyond the expiry date. Hence,
how many days? 1 day?
1 day. And we were.
Why don't you accept it?
We do not have the authority to condone such delay, your lordship.
Why?
We are strictly bound by the terms of the auction terms and conditions.
Is there anybody else who will be adversely affected if you
No, your lordship.
accept the petitioner or
They were the
condone the
sole
delay?
They were the sole bidders, and the property has
Why
not.
don't you accept it? It's only for a day.
I do not have the authority, your lordship. If your lordship gives the direction, then I may.
All right.
As per the terms and conditions,
Very
we
well.
cannot condone
Please
the
come. The matter. No, the interim order that is subsisting in the matter is extended till 30th of June 2025 or until further order, whichever is earlier. Stop. As it appears that the petitioner may have delayed in making payment only by a single day, and there was no other bidder in the auction apart from the petitioner, pendency of the instant writ petition will not stand in the way of the authority to reconsider as to whether there is any requirement of rejecting the petitioner's bid and forfeiting the bid amount and the poundage fee. Stop. If a day's delay can be condoned by the authority, then the authority may proceed to accept the bid of the petitioner. Returnable on 16th of June. Take a decision in the meantime.
And may I be permitted to file the affidavit in reply to the opposition? I'm grateful.
Reply filed by the petitioner to the affidavit filed by the authority. in court today be retained with the records.
But may I also make one more prayer, my lord, if the interim order in the meantime may be extended?
Extended. 30th of June, I have extended it.
Item number 3.
I appear for the petitioner, my lord. This has come up at my instance, my lord. I have served, my lord.
ठीक है जी, ठीक है, come.
This petitioner, my lord, before your lordship, my lord, is aggrieved by the inaction on the part of the Information Commission. Not only the Information Commission, the SPIO, the First Appellate Authority, as well as the Information Commission. After filing, my lord, may I just indicate two things? After filing of this application, he was called for a hearing, my lord. And in
By whom?
By the Information Commission, Second Appellate Authority.
Second appellate.
Lordship. And thereafter, my lord, in course of the hearing, my lord, he had directed the SPIO to furnish the information that has been sought for by the petitioner, my lord. That notice, my lord, your lordship will kindly indicate.
So has the information been supplied
No.
after direction of the commission?
No.
Still not. What is the information that you are seeking?
Kindly come to page 34. What had happened before your lordship goes to page 34? May I just indicate the background? What has
No, what is the information you want?
Page 34, my lord. This is the original application dated 27th of July 2023. My lord, he and his mother, my lord, he is a primary school teacher. He and his mother was indicted in two criminal proceedings, one 498A and 406. In 406, the petitioner's mother was discharged. But in 498 and 406, they were on bail. And on the basis of the injury report, my lord, this petitioner and his mother, my lord, they were arrested. And FIR was registered, charge sheet has already been submitted. But though charge sheet has been submitted, the trial is yet to commence. But this, whatever information that I have sought for, my lord, these will be required because these have been used again.
1 minute. Page 35. Page 35, these are the informations that you want. The below mentioned notes are for your kind information.
Lordship will kindly turn to page 34.
34.
Kindly
inform me the date of admitting to the hospital.
Admission, my lord, that is there. But DE, doctor's prescription, injury report.
Doctor's prescription provided.
Injury report. Page. And then F, my lord.
F.
Next page.
If any investigations were advised to the patient during treatment.
These have not been given.
Kindly inform the patient was advised whether they are done.
Thereafter, my lord, the petitioner had filed the first appeal before the First Appellate Authority, and the First Appellate Authority was kind enough to direct the CMOH and
SPIO, CMOH, you'll be representing who?
No, I'll be representing. The second appeal is pending. Kindly direct him to dispose of the second appeal.
No, second appeal, but the information has to be provided by you. Give the information.
They have taken up the hearing of second appeal. He's for the second appellate authority.
We have taken up the
Seek for information. Have you sought for information?
already
Sought for
the information that has been served, my lord.
From the First Appellate Authority and the original authority.
The information that has been served, my lord, that is not correct. Because
which information?
The information they have sought to serve, my lord, that was in respect of another RTI that was of 21st of June. Here I have
not this one.
Not this one. That is the whole difficulty, my lord.
Please take in instruction. Doctor's prescription provided on 1st of September 12, 1st of July 2022.
34.
If any injury report was
34 is the second appellate authority, my lord.
34, no, application.
Original application.
It's all section 6 applications.
Yes.
So, my lord, that is pending before he can direct.
No, please. The Chief Medical Officer of Health, which place?
Now, lordship will kindly turn to page 39, my lord. Because
Krishnanagar.
MOH, my lord.
Krishnanagar.
Krishnanagar.
Nodia Krishnanagar is directed to forward the information. to the queries made by the writ petitioner appearing at acha query number ta bole din to
all queries, my lord, all information dated 27th, my lord.
A2I
A2I.
appearing at pages
My lord, not I.
GHI
I.
at pages 34 and 35 of the writ petition.
Lordship will kindly indicate the date also.
Date
27/7/2023.
Where is the
Page
date?
36.
আচ্ছা বললাম কি বললাম অ্যাপ্লিকেশন কিছু বললাম queries made by the petitioner on 27th July 2023, released when 16th. Today we are on 19th.
Not sure.
So 16th of June. Enough time. Affidavit of service taken on record.
It shall appear on 16th, your lordship. I'm grateful.
Not sure.
I appear for the petitioner, my lord.
Yes.
Regarding, my lord, a challenge to a tender process, my lord, the decision which has been, my lord, passed without, my lord, any reason. I know my limited scope, my lord, in a, my lord, challenge to a tender process. Kindly straight away comes to volume 2, my lord, page 381, my lord.
Tender floated by?
Tender floated by Southeastern, my lord, Railways. This is, my lord, for the purpose of development of freight terminals. My lord, previous year we had participated so far as Eastern Railways are concerned, same eligibility conditions, but I know I don't have as a matter of right, my lord, to get a tender even for the subsequent year. But I want to show, my lord, from two documents, the prima facie case, why I say, my lord, this should not have been, my lord, rejected. My lord, kindly comes to 381, my lord, volume 2, annexure P8. My lord, this is, my lord, the rejection, my lord, communication. Your techno-commercial bid against tender number such and such, which was due on such and such, has been found technically unsuitable due to the following reasons. Comments, disqualified in technical evaluation. Well, this is the only reason. Well, he says that for the following reasons, but the reason indicated is again disqualified in technical evaluation. Now, only one document as a prima facie case to show, my lord, why this is bad, my lord.
First,
my lord, I may glad my Mr. Bishop.
No, sorry, my lord, I'm kindly pardon.
It's all right.
Now, kindly seize this language at page 381 once again. Your techno-commercial bid such and such has been found to be technically unsuitable due to following reasons. Now, comments, the reasons are not given. Disqualified in technical evaluation. So that it is an unreasoned thing. I mean, please fall back, to whatever I had uploaded at the time of technical evaluation. Please come to 176 of the papers of
What
volume 1.
is the status of the auction?
The status of the tender. The status of the tender, my lord, it is yet to be finalized.
My lord, I am the successful bidder. Award has been already given to me on 3rd of April. My work has already commenced. 3rd of April. My lord, the technical bid was rejected, my lord, on 7th of March. They are coming today. 7th of March, 3rd.
And you've already commenced work? You have already commenced work?
I have already commenced work. Letter of award was on 3rd of April. Work order was issued on 3rd of April.
Railway, do you have any instruction?
Can you see they have produced the balance sheet?
Balance sheet?
Yes.
Don't go to the
Audited
merit.
account, can you see?
Don't go to the merit. Tell me whether the work order has been issued and work has been commenced or not.
Not complied with the eligibility certificate.
Tell me whether work order has been issued, whether work has commenced. Please show me some document.
This is the work order.
Let me see whoever. Messrs. AIC Iron letter of acceptance.
Respond number 3.
What remains?
Please see 176.
What remains? He has already started. The work has also commenced. So you are
work is yet commenced, that is
work order issued. The letter of acceptance is a third.
Only one document I go. Your lordship will only one document. Kindly pardons me. Only let me try my luck. 176. Kindly seize once. Your Lordship has seen 381 and please see 176. My Lord, these are the two bidders who qualified in the technical. My Lord, one is Mr. Mukherjee's client, other is mine.
Yes.
My Lord, please see the compliance, technical compliance. My Lord, everything is complied.
No, no. If you had come earlier, I would have. Now, no. Please come.
Your Lordship is calling.
Nothing. Calling for nothing. Writ petition is being dismissed. The petitioner challenges the steps taken by the
I will be
Southeastern Railway
only
in accepting the bid of the respondent number 3 by rejecting the bid of the petitioner without any valid reason. Stop. Paragraph. Learned advocate representing the railway and the private respondent / the successful bidder places on record the letter of acceptance dated 3rd April 2025, accepting the bid of the private respondent. Stop. Learned advocate for the private respondent submits that work in question has already commenced in April 2025.
Not only two more sentences. One is, my financial bid, which apparently, as against his financial bid, they are losing. I am not giving more profit to the railways. The railways were likely to earn more. That is one submission. And second is, if I can persuade, that page 176 onwards documents reveal that I have complied with all technical.
Had you come earlier, I would have.
Kindly
at this stage, no.
Keeps the scope open, to take steps, if I have been wrongfully denied.
Already started.
You have to go before the suit court and get it done.
Yes, that is what that opening kindly keeps.
Acha. Ki bollam? Acha. As the petitioner appears to have approached this court at a belated point of time, the court is not inclined to exercise jurisdiction in this matter. Stop. Paragraph. As the learned counsel for the petitioner stresses on the fact that the bid of petitioner submitted a bid of more amount and the railways were supposed to earn more had the bid of the petitioner been accepted, a fact which is disputed by the respondents. The court is not inclined to enter into any disputed question of fact. Stop. It will be open for the petitioner to approach the competent forum for remedy, if so advised.
Not only one, only one indulgence.
Taken on record. What is it?
A supplementary affidavit to be placed on record because I have inadvertently not disclosed receipt of the EMD amount. I am giving a copy.
Not disclosed
the receipt of the EMD.
You have received it. Yes. So earnest money has also been. Come.
I am handing over copies to my learned friends.
Supplementary affidavit filed by the petitioner be retained with the records.
Dismiss.
I am for the petitioner in this matter. It is already subject to us considered by your lordship regarding the tender in respect of carrying the food items from ICDS project from FCI. That order tender condition contained a clause each year, particular amount. Lordship has decided the same at page 65. Lordship will kindly come.
Yes.
I shall take your lordship to the two aspects of the matter. Paragraph 9, where 50-50 ratio was given to me. I was given the lower quantity of orders so that I could not reach the demand they are making. And finally, your lordship was pleased to hold at paragraph 20 that this particular insertion of the word each year.
Yes, it cannot be made
Cannot be
applicable
made
if the same
applicable
is
here.
to be treated as a
Malar,
continuation.
again, the tender has been issued. Malar, notice has been, tender has been issued. Malar, with the same condition. Malar, the Lordship will get it at page 72. Malar will get it at page 75. At 75 holo, oita chilo credential. Credential has been mentioned in page 75.
Last 5 years is 80 lakh.
80 lakhs
Only for each year.
for each year. This each year has been set aside by Lordship on the last occasion.
But that is of a different pretext. It's a new tender, my lord.
That was the issue, my lord.
In terms of his lordship's
In
order.
order to allegations were made before by us, which our Lordship has to try, my lord, the issue. Lordship has on the face of it, but found it inconsistent with the earlier notices. Earlier means
Subsequent order, my lord, has been merged with the that earlier order.
24, 25.
If he is not eligible, my lord, then he has no right to participate and unnecessarily wasting everybody's time, my lord. It's a new tender in terms of his lordship's last order. First line, my lord, will find.
This is not a continuation. This is
No,
a
my lord.
fresh
Fresh tender.
notice inviting e-tender. If you fail to qualify according to the credentials,
And
then
that particular,
somebody else
well,
will come.
there is a clause of the finance department. If the tender is is such a harsh cost, so you have to relax it. And accordingly, it was
Let the authority see whether the authority gets any bidder or not.
Yes, my lord.
bidder only one bidder. That who has been
That is,
given.
my lord.
Lordship knows that, my lord, that person wanted to intervene in the matter.
Increase your workload.
Yes,
Workload has not been increased. I am 50-50. But I have been given the lesser number of work. Paragraph 9, Lordship has dealt with.
Can be done. This is a
Lordship has
fresh.
dealt with it. Lesser number of work. What is the intention behind it? Again, Mala repeating what is the purpose they are wanting to achieve at.
That's what, in terms of his lordship's last order, a fresh tender notice has been issued.
Fresh
This
what?
inviting
Fresh does
e-tender.
not, Mala, by itself, Mala, does not, Mala, implicate
Dated
same work can
24th
be given in a
April
new
2025.
cup of tea.
Published by the district magistrate and collector, is impugned in the instant writ petition. Stuff. The petitioner submits that the credentials fixed in the NIT is very harsh, and the same has been tailor-made only for a particular candidate. Paragraph. The court is of the opinion that the terms and conditions of a tender document is fixed as per the requirement of the authority. Step. The tender issuing authority is the best person to adjudicate as to what will be the terms and conditions on which the successful bidder is to be selected. Stop. Paragraph. It is not for the court to fix up any terms and conditions or credentials of any tender process. Stop.
Kindly not, Mala, that is not
In
the
view of the above,
Lordship dealt with in paragraph 9
the
of the earlier judgment.
court is not inclined to interfere in the instant writ petition. The writ petition fails and is hereby dismissed.
Only prayer I am making, my lord, the tender process has not yet started, my lord. Tender process started, but the tendering, my lord, the bid has not been deposited as yet.
Let him participate, but who prevents?
Who is eligible? Then I can participate.
If he is not, then
eligible.
unnecessarily he could not file any case unnecessarily.
He cannot do this, I cannot be suitable for that. May it be after the vacation, let them produce before a lordship as to who
Certainly
has
not.
given the first bidder.
Item 9.9 for the state respondent.
Yes. Who is there?
I'm for the petition, Lordship. With me, affidavit of service.
Marketing Regulatory
Yes,
Committee.
Marketing Regulatory Authority is required to be present before his lordship.
Lordship, prior to making my submission, Lordship, I candidly want state one thing, that those vehicles which was captured by the authority, has already been released by the said.
So the writ petition has become infractory.
No, Lordship. The difficulty is that on several occasions, this authority demanded money on the basis of such kind of statutory provision. And on various occasions, Lordship, they got their money 1% of the entire consignment amount. So this whimsical act, Lordship, is required to be scrutinized by this Honorable Court. Otherwise,
Very well. Is anybody appearing for the regulatory committee? None appears on behalf of the respondent numbers
4, my lord. 4 and 5.
4 and 5. Stop. Let further notice be issued. Stop. Released on 9th of June.
Much okay, Lordship.
I may affidavit of service.
Yes.
Westbengal Medical Council.
Medical Council.
Westbengal Medical Council. The allegation is the National Medical Council for not to dispose of his application appeal. We have already passed the order. They have prepared the appeal before the National Medical Commission. They are not disposing that.
You know, the one aspect of looking at the issue is what my learned friends just now informed you. My first submission to your lordship, kindly looks into the act.
Where is the impugned order?
Page 89.
Page 89.
Page 89. P11, annexure P11.
Kindly seize the act.
Page 90 is your appeal. The Honorable National Medical Commission against the order of the Medical Council, 26th of March, 2025.
Now, your lordship has seen 89. Now, when Mr. Das approached me, I was of the view that the preliminary inquiry that was conducted, insofar as the Professional and Ethics Committee of the West Bengal Medical Council, whether it is in sync with the law. Now, my lord, I have been able to lay my hands. Yes, it appears to be that there was some law which prescribes, which permits them to have a Professional and Ethics Committee. My first submission to your lordship is at that stage of extraction of documents and evidence from me, no opportunity of cross-examination was granted to.
But all these points are there before the appellate
if it is
forum.
patently without jurisdiction, kindly cease the act now. Now, please come straightway to section 17. We are concerned with 17B. Every person who possesses any qualifications referred to in this, subject to the provisions contained and on payment in this behalf, by regulation may not be entitled to his name entered in the register of registered practitioners, provided that the council may refuse to permit the registration of the name of any person B, whom the council, after due inquiry, at which an opportunity has been given to him to be heard in his defense, and to appear either in person such and such in the discretion, have found guilty by a majority of 2/3. Pausing here. On the 8th of May, upon approaching them, I have received the certified copies of the entire proceedings. It appears, admittedly, two opportunities were accorded. First opportunity is on the 14th of May, on the 7th of February 2025, when I did not receive any notice on that particular day. Prior thereto, on the 6th of February 2025, it appears that the complainant made his submission before the council.
But then B is mentions have been found guilty by a majority of 2/3 of members.
Let us take the entire council is against me.
No, this is your name was registered.
Yes.
Already.
Thereafter,
Registration.
this is for first time
25
registration.
5, my lord. 25.
Then 25.5.
20 as per 25.
25.
25A.
25A2. The council may direct whom the council, after due inquiry in the same manner as provided in 17B, have found guilty.
17B is only if it is infamous conduct, as it is mentioned
Infamous conduct.
later on.
My lord, what I am trying to, my lord, harp on is, my lord, no opportunity was extended to cross-examine. No opportunity was extended to meet
These
the
are all
allegation.
these very good grounds to go. And since you have already preferred, it's not that you have not preferred.
My lord, if the
You
order
have
is
already-
patently without jurisdiction,
Nevertheless,
or in excess of jurisdiction or beyond jurisdiction, my
you
lord,
have
then your
already
lordship may
approached.
interfere.
You have already approached.
My lord,
Prior to
there is no appellate forum today. My lord, there is no appellate forum. My lord, 111.
No, page 90 you have
No, my
filed
lord, please see 111.
111.
My lord, these posts are vacant.
First appellate authority.
The first appellate authority, my lord, these persons are not there. Only, my lord, Mr. Warde is available. Oh, I'm sorry, my lord, his tenure is also already over. So, my lord, today, as on date, there is no appellate forum. Even if I have carried an appeal,
please check whether the appellate
First
forum.
appellate is the state government, my lord. Kindly see page 89.
Section 30 subsection.
My lord,
Even
Section
I
26,
saw
appeal to the local
this.
government from the decision of the council. Secretary Health Department is the first appellate
my
authority.
lord, section 30.
Subsection 3.
Now, please see section 30 of the Act.
Section 26, an appeal shall lie to the local government from every decision of the council under section 17 or section 25. Every appeal under subsection 1 shall be prepared within 3 months from the date of such decision. Local government.
Your attention has been drawn to the provision of section 26. Appeal to the local government from the decision of the council.
But I have taken out an appeal under section 30 of the NMC Act.
That is also maintainable.
And that is also maintainable, my lord.
But then if the authority is over here and somebody is not.
Subsection 3.
My lord, please see section 33. 30 subsection 3. Wait, ভুলিয়ে আছে দু মিনিট আমি যাবো এখন এক্ষুনি যাবো এক্ষুনি আমার
First appellate authority is ethics and medical registration.
Bombay judgment.
There is a provision for second appeal also.
The second appeal is before the National Medical Commission.
First one, you may prefer an appeal to the ethics and the medical registration
That is what I have
board.
done. I have done it before the ethics and medical board. Now, please see page 111 once. Ethics and Medical Registration Board. That is 30 subsection
Or
3.
as the case may be, the state medical council shall give an appeal and state medical prefer an appeal against such action. The Ethics and Medical Registration Board.
ওটা হেডিংটা ওদের তাই দিতে
Thanks. But then see, page 89, the
Fine.
impugned order specifically mentions about section 26 of the Bengal Medical Act.
I can, Milord,
You have another forum also.
saying, Milord, that's a concurrent forum.
Yes. If that be so, if one of the forum is available, why will you not avail that forum?
And
you
if I
go
can
before
persuade your lordship that page 89 has been passed without hearing me, then Milord, perhaps Milord, I do not, Milord, require to file even an appeal. Milord, if it is proved, Milord, I shall, Milord, take this chance. Let them produce, Milord, whatever the minutes are. I go out of court, Milord, I shall take this chance. Even if your lordship saddles me with, Milord, anything, I
Is
shall
it,
take this chance.
is,
It is without, Milord, hearing.
There must be a complaint filed against you.
That complainant was heard on a particular day, 6th of February. I was not given any opportunity to meet him, to even cross-examine him. I was called upon over telephone on the 6th of February 2025 saying, Ajge hearing ache, why are you not here? I say that I do not receive any notice. Please come and take the notice. I go on the next day. They make me sit there. Milord, it is a put on of everything. Milord, they make me sit there, make me sign on, Milord, sheets of papers, questionnaires, and Milord, the hearing is over. And on the basis of that, on the 7th itself, the council, after closure of this, on the 7th, documents are luggage, supplementary. In the supplementary, it is a part of the records. Milord, kindly see. Sir, please. Milord, please see. Milord, please see 7. Please see 7. Page 7 onwards. This is excerpts of the proceedings of the extraordinary meeting of the council held on 6th February at 12 noon in the meeting room of this. Hearing in respect of charges framed against Dr. Barik, such and such in connection with a complaint received from Kishun Sharma regarding negligence of treatment of her daughter Kollani Sharma and her resultant death. This deposition of Sri Kishun Sharma, I am not present. Where do I get it? Here, in the middle. The council noted, while the complainant was present, the charged medical practitioner did not turn up. My specific averment is I did not get any notice of this. Then, the council decided to give a complainant hearing considering his presence by honoring the notices of the council in this respect as well as his advanced age. Then the deposition is taken. Then 7th. Next page, page 8. Excerpts of the proceedings of the extraordinary meeting held on such and such on 7th February at 12 noon. Here in respect, the council recalled its decision taken during the previous meeting to call the charge and noted that he had reported by responding to the notice of the council. The council then called him in. The following charges are read. Then the council invited the charged medical practitioner to state his case, which he did. And he did his case, and ultimately, question answers recorded. And then straightway, kindly come. Page 11. The chairman then called upon the members to vote on the question whether Dr. Barik was guilty of infamous conduct in a professional respect. The council unanimously decided that the charges brought against the charged medical practitioner have been substantiated. Without any opportunity, no cross-examination, nothing. I did not even have the opportunity to meet the allegations in a manner known to law. I cannot be condemned unheard, Milord.
And see, the whole questionnaire is there. That means not that you are not hard.
I was hard, but there was no opportunity. The law prescribes, the Medical Commission Act, the Council Act, prescribes, an opportunity of hearing.
Can this not be treated as a hearing given to
it
you?
is a hearing, it's one-sided. I did not even get, the statements. It is only, this kindly sees the dates.
Where is the complaint? This is complaint of the complainant.
True copy. This is only I received on 8th of May.
Which page is it?
This is page 7 of the supplementary.
Yes.
And the complaint of the complainant,
Is it there?
Complaint of the complainant.
That must have been forwarded.
Yes, yes, yes.
Page 46.
Page 46. This is of 2021, to which I respond at page 20, at page 48.
Firstly, the complaint was made before the regulatory commission. They have imposed 5 lakh.
Yes, that is another thing. That is on the hospital.
Page 46.
Yes, 46 is the complaint, 48 is my immediate response. Then, Milan, after 2 years, at page 51, the so-called committee, Milan, the preliminary inquiry committee, this is the professional and ethics committee.
Yes.
They call me for a hearing, which I attend. Again, Milan, I give my written deposition. Again, no cross-examination. All these persons, and Milan, who is this expert? I put this question entirely to myself, Milan. Please see page 60. Milan, 60. Just give me 2 minutes.
Would you like to produce documents in support of your stand, or would you like to file an affidavit? I am not in favor of granting an interim order. If you want to continue with the writ,
file the affidavit if my lord direct.
no interim order. But then you still have a chance in appeal. I do not know what is going to happen. And a supplementary affidavit filed in court today is taken on record. Stop paragraph. The petitioner submits
one
that.
judgment I need to show your lordship, Milan. Paragraph.
Paragraph 12.
Now, please see paragraph 12 of this judgment. This is 2022 SCC online 9252. Paragraph 12. In the context of section 32 of the 2019 Act, it is seen that the State Medical Council has the power to take disciplinary action against any professional or ethical misconduct by a registered medical practitioner or a professional. While doing so, it can impose penalty as a remedy against such action by the state medical is provided under section 33, being an appeal to the Ethics and Medical Registration Board. A further remedy under 34 is provided before the National Medical Commission against the order passed by the Ethics and Medical Registration Board. Under chapter 8 of the regulations, which continue to operate even today, punishment and disciplinary action has been prescribed. Under regulation 8.2 of the State Medical Council can direct removal either of for a specified period or altogether the name of the delinquent registered medical practitioner or professional from the register maintained by it. The remedy of an appeal has been provided under regulations 8.8 thereof. It is true that no provision has been made for staying the effect of the disciplinary action taken against a registered medical practitioner or a professional by the State Medical Council during the time the appeal preferred by such aggrieved registered medical practitioner or professional is considered either under 33 or under 34. It is likely that as a consequence, by the time the appeal is decided, the penalty awarded by the State Medical Council would be suffered. As stated above, removal from the register can even be for a specified period, which period could come to an end even before the appeal is decided. It is in this backdrop that the incidental power to at least preserve the status quo ought to be recognized as existing with the Ethics and Medical Registration Board while entertaining an appeal under section 33 such and such. Recognition of such incidental power to stay the adverse action taken
In that case, go before the board if you want to obtain order in this line.
There is no board today. There is no board today. As
there is, the state government is there. The other appellate forum is there.
That if today I can persuade your lordship that I was not afforded an opportunity of hearing.
Let him come and say. Is taken on record. Stop. The petitioner is aggrieved by the order passed by the Medical Council. In its extraordinary meeting held on 7th February 2025.
Kindly pardon me,
finding him guilty of infamous conduct in his professional duties and directing the removal of his name from the register of registered medical practitioners maintained by the Medical Council for a period of 2 years. Stop. The order impugned mentions the provision for appeal under section 26 of the Bengal Medical Act 1914. Stop. The petitioner, however, prefers an appeal before the
Ethics and Medical Registration Board of the National Medical Commission.
Ethics and Medical Registration Board of the National Medical Council.
National Medical Commission.
National Medical Commission. In March 2025. and submits that the said board is non-functional at present. So prayer has been made to stay the impugned order till formation of by the board. Stop. Formation of the board. Achha. Prayer has also been made to set aside the impugned order as the same was passed without granting proper opportunity to cross-examine the complainant. Stop. It has been submitted that though the petitioner was given a questionnaire, it has been submitted that the petitioner was given a questionnaire which he had to fill up, but the petitioner never got the opportunity to cross-examine the complainant and the other witnesses. Stop paragraph. Reliance has also been placed on the judgment passed by the Bombay High Court in the matter of Dr. Ashok versus National Medical Commission, New Delhi and others. Reported in 2022 SCC Online BOM 9252. 9252. Stop. Paragraph. Learned advocate representing the West Bengal Medical Council submits that the appellate forum under section 26 of the Act is very much functional and the petitioner may approach the said forum. Stop paragraph. As the petitioner stresses upon the fact that there has been violation of the principle of natural justice, the court directs the West Bengal Medical Council to file an affidavit disclosing its stand as to whether proper opportunity was given to the petitioner to cross-examine the witnesses and the complainant. Stop. Let such affidavit be prepared and circulated by 12th of June.
Cross-examination is Supreme Court upheld in the matter of Kunal Shah that there is no possibility of cross-examination by the council. My lord knows it.
You file it, let them also answer.
I am handing over the judgment, my lord, of the Kunal
Not the
Shah.
judgment. You show whatever you've got to show. Apart from this, you go through it once. Apart from the documents which are here, if you feel that there is no other document required, then the judgment can be seen and order can be passed. All right, it is up to you. Choice is yours. Achha. List on
Kindly record that the
18th of June 2025. Stop. Reply, if any, may be filed by the petitioner prior to the adjourned date.
kindly record my submission that the cross-examination is not needed as per provision of.
Achha, learned advocate for the council submits that there is no scope for granting any opportunity of cross-examination to the delinquent doctor. Next.
My lord, let this have a copy of the order to the National Medical Commission as they was not represented today.
But I shall, sir.
Let this order be communicated to the non-appearing respondents. দেখছি তো তাই
Lord, this is my application, my lord. This is challenging one order of blacklisting, my lord, effective blacklisting, my lord. Tender holiday have been placed, my lord. This is dated 26th of March 2025, my lord. My lord, the petitioner, my
Who
lord.
are you representing?
I appear for all the respondents. Two respondents only. I appear for.
Garden Reach Shipbuilders. Yes.
My lord, the petitioner's firm, my lord, is a micro industry, my lord. It has all the, my lord, requisite certificates, my lord, from the Udyam board, my lord, the commission and all. My lord,
Show me the order, please.
My lord, it's at page 30, my lord. My lord, if my lord comes to the second paragraph of this, or rather the first paragraph itself, my lord, the firm is being put on tender holiday and suspension of business for 36 months with immediate effect due to repeated failures and / or action slippage in adhering to contractual milestones or final delivery schedule / commitment or contractual service obligations and poor / inadequate support after sale service. My lord, immediately after that, my lord, comes to the next paragraph, is that the same thing is written again, my lord, with a minimum period of 36 months. My lord, after this, my lord, there are certain other conditions that are there, my lord. The second and the third condition, my lord.
Tell me whether this order was passed upon giving you an opportunity of hearing.
No, my lord.
No?
No.
All right.
My lord, in this, my lord.
What work were you given which you failed to perform?
That is the thing, my lord. The last contract that was carried out by my client, my lord, was in the year 2024, my lord. And even that tender, my lord, was after issuance of the work order, my lord, was cancelled, my lord.
So you did not perform any work?
Yes.
And what was the reason for cancellation?
My lord, my lord, I shall have to take
These
instruction, my lord.
documents are not here, my lord. I am carrying all those documents, my lord. This is a contractor who has continuously defaulted in performance of his obligations. I am carrying emails of January 2024, May 2024, all of
In
them showing
respect of the earlier work
earlier
order?
purchase orders. So, my lord, one other point, my lord. Firstly, this is a habitual default, my lord, in respect of contracts awarded to him. Apart from that, my lord, perhaps this writ petition, my lord, is not maintainable because there's an alternative remedy. My lord has noticed the word minimum for 36 months. The reason is the tender holiday that is placed on the petitioner today is subject to review, and that is provided for in the rules
My lord,
itself. Page
after
85.
36 months, my lord.
Page 85.
Page 85, my lord, kindly comes to page 85. Page 85, clause 6.14. My lord, we'll see there's a provision for review. This is really premature at this stage without them having even served a single representation on my client. They can make a representation, let it be considered in accordance with this clause, and we'll take a decision.
Before 6 months of the expiry of the period
Yes,
of tender.
so 36 months. So they can apply at any time till 30th month of the 30th month of the tender holiday. The word holiday is missing, but on
Yes.
instruction, my lord, I'm indicating, my lord, they can apply at any point from 26 months till 30 months thereafter. It's still open to them. That I'm submitting on instruction, my lord.
No, but first tell me whether this order was passed upon providing him an
My
opportunity.
lord, as per the rules, firstly, my lord, two incorrect submissions, if I may say, my lord, have been made. The tender holiday is not really a blacklisting. I will indicate page 81 if my lord comes to. This is only a determination by my client, specifically Garden Reach, to not issue further work orders in favor of this vendor.
And
because of his
suspension of business also.
suspension of business only. My lord, 81. I'll indicate, my lord. That is clarified. Page 81, my lord, will kindly come to. Sorry,
81.
80?
I'm sorry,
81.
83. 83, my lord.
Yes.
83, I'm referring to. 83, my lord, will kindly come to the two last lines of para 6.4b. This tender holiday will not, however, amount to the vendor being banned or blacklisted from doing further business with the government PSUs. This is not in respect of any other government PSU. This is my client. My client had issued prior work orders. They had defaulted. Therefore, my client does not want to do business with this person. We have issued a tender holiday in respect of our concern only. It does not prevent him from participating in any other tender with any other government PSU. That's clarified here. This is clarified here. And in respect of the tenure of the tender holiday, my lord, they're at liberty to file a review petition or a representation for that effect that will be considered by the standing committee. Also, the notice that is required, page 83, the first paragraph, my lord, C, that 6.3C, my lord, will see it requires us to issue show cause notice. This, my lord, on instruction, the practice followed by my client is in respect of each purchase order or each work order that is issued, notices have been served upon him, telling him to show cause as to why punitive action has not been taken in respect of each purchase order. I'm carrying some of
How
these
many
documents.
purchase orders?
My lord, for the time being, I've been furnished with two. I'm
Two.
having two letters. I can
Alright.
I can indicate. My lord.
And the petitioner says only one.
I have, on instruction, my lord, I have completed all of the.
Yeah, please come.
My lord,
The
if,
petitioner is aggrieved by the
Lord, if
notice
I may
for
show one
tender
thing,
holiday and suspension of business issued by the Garden Reach Shipbuilders and Engineers Limited. On 26th March 2025.
Put the notice.
Notifying that the petitioner has been put on tender holidays holiday and suspension of business for 36 months with immediate effect. Stop. Paragraph specific case of the petitioner is that no opportunity of hearing was given to the petitioner prior to passing the impugned order. Stop. Violation of principle of natural justice has been pleaded.
My lord,
Paragraph.
my lord, I may interrupt, my lord. My lord takes the notices that have been handed. My lord, this does not mention anything about show cause, my lord.
Very well. Learned advocate representing the authority submits that due show cause notices were issued to the petitioner prior to passing the impugned order. Stop. There is a provision for review. Stop. There has the allegation of violation of principle of natural justice has been denied. Stop. Paragraph. The respondent authority is directed to file a report by way of affidavit disclosing all facts and figures and circulate the said affidavit by 13th of June. Exception, if any, by 20th, list on 25th.
My lord, my lord, in the meantime, my lord, this tender holiday, my lord, does not cause any effect to, my lord, to other bids or tenders that he may apply for,
My
my lord.
policy itself.
There is nothing.
My lord, since, my lord, other tenders, my lord, that he has to apply for.
They means not the Garden Reach. There may be other
Yes, my lord.
authorities.
My lord, even in those tenders, my lord, they have to specify that whether there is any order of blacklisting against
There
them.
is no order of blacklisting. This cannot
But
be
this
treated
tender
as a
holiday,
black.
my lord, would it?
This is not an order of blacklisting.
Yes, my lord.
This is a temporary suspension and a holiday type of. This is a new term that I got to
Yes, my
see.
lord,
It's
but
the
this,
holiday, tender holiday.
yes, my lord.
Right. So it's not
My
blacklisting
lord,
as
but
such.
my lord, the words of the tender holiday, my lord, would amount to, my lord, of blacklisting against Garden.
Don't
as against
plead
Garden.
against you. You should plead that no, it is not an order of blacklisting. Right?
Great. My lord, the affidavit of service.
Yes.
My lord, I appear for the petitioner. My lord, the only question involved, Lordships may not be requiring to see, is in case of tie among the L1, what will happen? But my lord, before I proceed, my lord, I thought I must say this. I discovered a private respondent is not made as a party.
Somebody's bid has been
It is
accepted.
in the midst of it.
The tie member.
Yes. Now there are 10 all L1.
Yes.
The
10 L1s.
10 L1s. Well, it is for in a hospital
supply of
sweeping and housekeeping. That
all right.
Now
service providers.
Now the original clause was in case of a tie there would be lot draw
of lots.
But 2022 government made a memorandum saying in case of a tie the consenting parties you can give it so that if they are agreeable.
Distribution of work.
Now here 9 of them they agreed that no matter we would be happy with the small amount distribute, but one he has been singled out for no reason.
Single out means?
Single out means 10 L1.
Yes.
Now, the principal, he himself took a decision that
division will be among 9.
No. As per the memorandum, the work has to be given to by devising the number of works to all the L1.
Yes.
For that, there is a requirement of consent letter.
Right.
Consent letter has been submitted. But he has chosen not to devise it, and he picked someone who did not give consent. That's the case. But that someone
is not a party.
He must have been a party.
Yes.
So,
all right. And when in the work order will be issued or something?
I'm with the instruction.
May I say this? My lord, this is, may I just say, I know that in the prayer they have used the words that there is no such document for issuance of the work order. But in the prayer, they have couched in the language as if the work order has been made. But I would most likely what has happened, my lord, the work order is in the process of being given. And this work order is basically, my lord, providing some persons for the purpose of sweeping. And the petitioner before your lordship, since 1996, including the COVID period, he took the, my lord, I can use the word trouble, and satisfactorily has done this work. It's not that he's not capable of doing it. Now, so his language is against me the way it has been drafted, but I believe that work order is yet to be issued. Decision has been taken.
Financial evaluation was done on 29th of April.
Lordship, if Lordship, just 2 documents. That first is
95 days.
The
cleaning and
31
household services. Yes.
Providing, kindly see, only for the purpose of what is the nature of job.
Cleaning and housekeeping services.
Yes, only that.
Yes, yes.
Now, kindly come to.
What is the instruction?
My lord, instruction is complete, my lord. Lordship, may I respectfully hand over lordship. My lord,
How
my
did it
first, my
select-
lord, is updation of the, my lord, tender. So tender is for housekeeping and cleaning, lordship. My lord, kindly comes
Give
to
a copy to him also. He'll get to know what is there.
Yes, kindly comes to page 5 of the, my lord, instruction, my lord. The award of contract, my lord. It was on 29th April, my lord, 2025, my lord, page 5. And my lord, jurat of the writ says that they have affirmed it on 14th May, my lord, 2025. That's my first, my lord, humble, my lord, submission. Secondly, my lord, yes, L1 bidder, there was a tie. You know, my learned friend, my lord, has adverted to one memo of the, my lord, this finance department. My lord, that is second leg of my respectful submission. Situation 3 has arisen. So, my lord, may I respectfully, my lord, have you handed over my learned friend has annexed that, but it is illegible. So, my lord, I am handing over the legible copy of this, my lord, memo lordship. My lord, kindly comes to situation 3. My lord, that is page 3, my lord, of the memo lordship. What does it say, my lord? Kindly see in lordship situation 3. In addition to what has been stated in situation 1 and 2 above, the following procedure should be adopted when there is a tie among the L1 bidders. Keeping the discovered L1 rate as ceiling, sealed bids may be invited from all the L1 bidders. And out of those, the lowest one may be selected. If none of the L1 bidders is ready to offer further reduced rates, then what will happen? A, if the items are divisible by nature, it is divisible by nature, the work may be distributed equally amongst the consenting L1 bidders. Clause 2, if none of the L1 bidder is ready to accept the reduced quantity, the bidder with higher credential based on the following parameters may be selected among L1 bidders in the following manner: A, B, and C. The authority, as per the report, has taken records to, my lord. A,
B,
2,
B,
clause C.
Oh, C.
In case of supply of manpower, number of personnel supplied in a single contract during the last 3 years shall Y. My lord, may I respectfully invite your lordship to the, my lord, now, my lord, the instruction portion. My lord, first page kindly sees, my lord, there was a meeting of the tender committee, not he or she, my lord, the entire tender committee comprises, my lord, as many as, my lord, 3 members. Kindly sees the minutes of the meeting on 24th March, my lord, 2025. What does this say, my lord? Clause 1 says situation 3 of so and so laid down norms, invitation of bids for all N1 bid are found to be not applicable in the current scenario. Second, resorting to the next procedure, as the A1 situation 3, the proposal of equal distribution of work among consenting L1 bid are discussed. 3. In the meanwhile, tender committee meeting was impacted by representation made by the student representatives and staff representatives, with a major demand being allocating the work to one single company instead of multiple companies in the best interest. They brought forward the issue of one of the previous agencies, Skyland Security Organization, who had previously defaulted in payment of salaries, ESI, EPF benefit, and his termination for having been absconded all of a sudden. Now, 4 million is important. So, 7 of the L1 bidders were in favor of equal distribution. Among them initially, one of the L1 bidder was against the same, and another L1 bidder did not express his opinion. So this is the scenario of this 7 plus 1 plus 1. As discussed with the clause 5 and proposed by the committee, keeping in view the operational and administrative issue in the best interest of public service, allocating the work to the 8 L1 bidders will hamper general operations, patient care, and student affairs. The previous case of Skyland bears testament to the fact. Now, Miller 6 is important. Some of the bidders, although partially agreed prima facie to the above operational issues in principle, however, in the professional interest, highlighted the request for equal division. Now, Miller 7, Miller next page. Thus, it was made clear to all the L1 bidders present that the committee proposes to draw a reference to A to C, where it has been stated the number of personnel supplied in a single contract during the last 3 years shall be considered for allocation of the work. The committee members, therefore, decided to thoroughly delve upon the submitted credentials of all the L1 bidders in accordance with the above criteria. As per the analysis of the credentials submitted by the bidders, and in reference to point 6 above, point 6 million referred above, the statistics of all the bidders was discussed in the meeting, and confirmation regarding the same was also provided by all the L1 bidders. A further time of 48 hours was given to the above bidders to clarify the above statistics with reference to the bid submitted by them in the portal and convey the same through email along with. Now, what comes after 48 hours? After 40 years comes, my lord, this next page, my lord. 26 March 2025, meetings of the my lord, tender, my lord, committee, my lord. Kindly see what the discussion was and the decision, my lord. After lapse of 48 years, it was found that there has been no submission regarding any difference in statistics of manpower as was discussed during the previous meeting. The previous decision of the committee, that is keeping in view the operational and administrative issue in the best means of argument, allocating the work to 8 L1 bidders will hamper general operations, patient care, and student affairs was reinforced. 3 is important. Thus, the committee upheld the reference to Rule A, Clause 2, Subclause C, where it has been stated the number of personnel supplied in a single contract during the last 2 years shall be considered for allocation of work. After careful and diligent and reanalysis of the credentials submitted by the L1 bidders and further deliberation on all other aspects, CFS, which my learned senior friend has not made a party respondent, emerged as agency in compliance to the above norms. Therefore, the committee resolved to award work order and execute contract with CFS when so for a period of 3 years. Now, kindly see me to the next page, last page. I will be referring to your lordship. Kindly see that was on 28 April 2025. So these authorities, they had taken the matter up to the my lord highest authority, or there is a department. That is clause 2 says, and clause 3 says, committee appealed the reference of so and so point 3, and therefore the committee finally resolved unanimously to issue award of contract and execute the contract with CFS. And my lord, thereafter come, my lord, the page 5, my lord. Now, third leg of submission, my lord, page 103. My learned friend is telling something about consent of all the my lord equal, my lord, L1 bidders. Kindly see 1031 page, my learned friend has annexed to the writ petition, my lord. It does not show, my lord, that it has. Kindly see, my lord, page 103, lordship.
Anyway, please come.
My lord.
Lord, may I make a quick response?
What will it be?
But on the point of this addition, I'm not saying it because that's my learned friend's point is that he accepts that there is a provision that in case of a tie, it should be based on the consenting persons. But there are 3 other subcategories. Now, the last subcategory is last 3 years number of total persons. I would not say it is unreasonable. All I'm praying, because I don't know because this gentleman, he was providing from 1996. My instruction is that he is the most competent and there has been no proceedings, no dissatisfaction with his work. Let the credentials of the private respondent who would be added as a party and my credentials be brought before your lordships. If it is found it is satisfying that clause 3, then I will not make any submission.
Please come. The writ petition revolves around a notice inviting tender floated by the Deben Mahata Government Medical College and Hospital. Stop. It appears that there were more than one L1 bidders. Stop. The petitioner was one of them. Stop. The authority accepted the bid of one out of nearly 8 L1 bidders. Stop. The petitioner is aggrieved by the same. Stop. It has been submitted that the petitioner is the most competent person to provide the service as sought for in the tender. Stop. The petitioner provided service to the hospital earlier for the longest period of time up to the utmost satisfaction of the authority.
And including the that COVID period.
Including during the COVID period. Paragraph. Learned advocate representing the respondent authorities relies upon the instruction forwarded by the
principal, the tender inviting authority,
the tender inviting authority. Stop. The minutes of the meeting of the tender committee held from time to time has been placed before this court, and copy of the same has been handed over to the learned advocate representing the petitioner. Paragraph. It appears therefrom that admittedly there were more than one L1 bidders. Stop. The authority took note of the memorandum number 2320-F within bracket caps Y dated 7th June 2022 where the procedures to be followed in case of a tie bid is mentioned. Now, are mentioned. Stop. Paragraph. The authority resolved that the authority observed that there is a provision for equal distribution of work among the consenting L1 bidders. Stop. The tender committee also took note of the fact that there was a representation made by the student representatives and the staff representatives with request to allot work to one single company instead of multiple companies in the best interest of the organization. Stop. The incident of one of the previous agencies who had defaulted in payment of salary ESI and EPF benefit and its termination for having been absconded all of a sudden was also taken note of. Stop. Keeping in view the operational and administrative issues in the best interest of the public services, the tender committee decided to award the contract in favor of the bidder who provided the largest number of personnel in a single contract during the last 3 years. Stop. "48 hours time limit was given to the bidders to clarify their stand with regard to the procedure sought to be adopted by the committee for selecting the appropriate bidder. After 48 hours, paragraph diye, it was found that there has been no submission regarding differences in statistics of manpower, keeping in view the best interest of the public, the tender committee decided to select the contractor who supplied the number of personnel during the last 3 years for allocation of the work. After careful and thorough re-analysis of all the credentials submitted by all the L1 bidders. And
reanalysis, the word is reanalysis, Lordship.
Reanalysis. And further deliberations on all the aspects, 1. CFS emerged as the agency in compliance of the norms set by the authority. The committee unanimously resolved to provide work order and execute contract with CFS Management Private Limited for a period of 3 years. The committee further held a meeting and resolved to issue the award of contract and to execute the contract with CFS Management Private Limited for a period of 1 year, with effect from 1st May 2025 to 30th April 2026, likely to be extended for a maximum period of 3 years. The award of contract has been duly executed. The document, the minutes of the meeting of the tender committee placed before the court contains the signature of the MSVP, principal, the accounts officer, the assistant superintendent, within bracket, non-medical, the pharmacist in charge, and the pharmacist করে দিন। ঠিক আছে? On a perusal of the documents placed before this court, it appears that the work order in question was issued in favor of the successful bidder, and the same took effect as a bidder in the in the end of April 2025, and the work order issued with effect from 1st May 2025. Stop. The petitioner has approached this court by filing the instant writ petition, affirming the same on 15th of May 2025. That is long after the work actually started. Stop. Paragraph. The successful tenderer has not been impleaded as party respondent in the instant writ petition. Stop. On a perusal of the documents, the stand of the authority in selecting the successful bidder from amongst the tie bidders does not appear to be unreasonable. Stop. On the contrary, it appears that enough deliberations were made by the members of the tender committee, and thereafter a decision has been taken to select the successful bidder in the best interest of the public. Stop. The court is not inclined to interfere with the decision taken by the authority. The writ petition fails and is hereby dismissed.
May I? Well, there is one point I just missed. Just one sentence. If Lordship take that page 94. But this only while I was reading, I discovered.
Yes.
There is Roman 1, Roman 2. They have chosen Roman 2C. Correctly, they can. All I'm saying, Roman C possibly can be attracted if Roman 2, if none of the L1 is ready to accept, that is satisfied.
I have recorded that it's in the interest.
It's not unreasonable.
And not only that, it is not only the court recording, the authority also took into consideration. And in fact, it is so, you say it is a work, particular nature of work. If you divide, it becomes very difficult to supervise.
Agreed.
You have in your home, in a personal level, you have got 10 staff.
I've understood.
Supervising 10 is difficult. It's easy to supervise one. It is only on that principle that
in my copy, the date of affirmation is 14th May. Lordship was pleased to write 15th May. Is it your Lordship's copy 15th May?
That must be right one.
Filing.
Ours are come better.
Maybe 14th it was affirmed and filed on the 15th because I see at the
My
top.
copy 14th May, date of in the jurat.
না না পেছন দিকে দেখুন হয়তো অ্যাফার্মেশনটা 14th এ হয়েছে মেবি 14/15 করে দিন affirmed on the 14th, filed on the 15th. It can always be.
Got it.
Affirm কবে 14th. Check.
But that doesn't make
much of a difference. Yes.
This is that matter. I'm for the petitioner matter. This is that matter, matter. That a loan of rupees 4,70,000 have been sanctioned in my favor in the year 2009. Thereafter, we have paid from time to time 6,30,000, including the bank went to the Lok Adalat, and in that Lok Adalat matter, the bank has got an order that we have to pay a further sum of rupees 72,000. And that is to be paid 9,000 per month. That has also been paid. Bank agreed to that order. And bank has given a no objection against both the accounts. Thereafter, my lord, the bank has issued a notice that against one account, the loan has been decided, settled, but the other account remains. But fact is, this bank cannot do so because this is a consent decree.
We're supposed to file an exception.
Exception, I have filed a supplementary affidavit specifying every facts.
Supplementary. And then did you give a
I have
copy?
given a copy to them.
What is your submission, madam?
Lordship, kindly make it not today, Lordship.
Why?
Because Mr. Debashish Shah is engaged in another court, Lordship.
The supplementary affidavit is voluminous than the writ petition.
Oh, no, my lord, because we have paid the money, 6 lakhs something that has been paid by us, that has been specified in it. The supplementary affidavit is of four pages.
All
The
these
payment
annexures.
receipts are there, which include so many pages.
Is the bank disputing your payment?
No.
Then?
Even then also, the bank says, bank has disbursed 4,70,000 against both the accounts. Now the bank says we have to pay further 4,70,000. Already 4,30,000, we have paid 6,30,000. Now bank says after a consent degree, without challenging that degree and without assailing that, they have said that no, you have to pay a further sum of 4,70,000. In the decree, both the accounts have been mentioned. I am placing that decree. If your lordships here,
Page 16.
Page 16, Page 16, both the accounts have been mentioned. Next, page 17, both the accounts are there.
Pre-litigation case number 1034.
1034 is the
settled, agreed, settled is for 72,000.
They have not challenged that degree, my lord. Now steps cannot be taken in that manner.
But then whether it is in respect of one or two.
Both the accounts. Accounts gulo kothay dekha? My lord, 1034 is of 2018 is that that case, and in that case that have filed by the bank, both the accounts have been mentioned.
Page 17, I can see two accounts.
No, both the accounts are there in the page 17. Number 1, DL so and so. Number 2, OD so and so. So against both the accounts,
that the opposite party have availed loan from the applicant bank to the tune of rupees.
As we have paid 6,30,000 already against 4,30,000, 70,000. Now thereafter, as per order of
17,
my lord,
paragraph number 1, please read.
Has availed loan to the tune of 1,70,000 and the present outstanding
and
loan is so and so.
1,70,000 in one.
In one.
And the next one is blank. And this is only DL. And
may I now?
It's not there at all.
May I now bring the plaint before the decree?
No, but then the order is in respect of only DL, not in respect of the OD. Account number, page number 17, there is DL and then OD. And see, serial number 1 mentions about DL. Where is the OD? So it means it was passed in respect of only one.
This is a humble petition on behalf of the opposite party. In outstanding amount.
In page 19, I can see there is a statement of the branch manager that there are two accounts in the name of.
So, my lord, another is
settled through local
rupees 1,48,817 and rupees. Another one is 1,70,000 so and so, and another is 1,48,000 so and so. Page 17, my lord. First paragraph. So 1,70,000, 1,48,817.
Let your other side come. Supplementary affidavit filed in court is taken on record. When is he coming?
Kindly fix it at 2 p.m.
2 p.m. it is not possible. I cannot fix time. Tell him to come. I'm passing it over.
Okay.
Then let it be tomorrow. Only
tomorrow?
Only not today.
Then day after tomorrow.
Day after tomorrow, as your lord. Then supplementary affidavit file may be recorded.
Yes, yes.
And I have served them.
Yes, yes.
একটু দেখে রাখ দেখুন। পুরোটা নিয়ে আসতে হবে তো মানে ডে আফটার টুমরো
21 IP, that Bengal excise matter, my lord, in which my scooty, my lord, was seized. My lord, my contention is 78 subsection 2, the district magistrate had.
Charge sheet.
Charge sheet.
Give, please, hand over copy.
Lordship,
Case number.
the only thing is that I'm quite surprised. My learned friend has not got the charge sheet.
It should have been given.
He should have been given.
But I am an accused. My lord, the court will give it to me on a date fixed for 207.
It is supposed to be given the charge
Yes.
sheet by the officer.
When is the date?
Date is, Your Lordship, the charge sheet has been filed on 3rd November 23, Lordship.
23?
Yes, Your Lordship.
Then the client has not given you proper instruction.
My lord, there is a date
Let
fixed.
me see. From 23
that
to
is-
25, you cannot say date has not been fixed for handing over of the charge
But
sheet.
this order was passed by the learned magistrate on 2nd of November 23. So on that day, my lord, the charge sheet was not before the court. My lord, that is why, my lord, the magistrate has passed the order that I do not have power, my lord, under the Bengal Excise Act. But I am not disputing, my lord, my learned friend is correct. But kindly, if it is on 3rd of November 23, the order in which the magistrate had refused is dated 2nd of November. So, my lord, the charge sheet was not there.
Please come.
My lord, may I make one prayer? My lord, subject to your lordship. My lord, now my remedy, my lord, since the charge sheet has been submitted, my lord, I have to approach the revisional jurisdiction. My lord, only thing is, my lord, the period of pendency of the writ petition, my lord, could it?
You have to obtain order from the revisional court.
My lord, only, my lord, I have to file a section 5, your lordship, my
Nothing
lord,
doing. I
only
am not.
says, my lord, the period of pendency of the writ petition may be kindly be condoned.
No.
Kindly, my lord.
No, no. Learned advocate representing the state respondents has placed before this court documents from the court, the instruction forwarded by the inspector of excise, Kollani excise section, Nodia, dated 28th December 2023. The same was submitted before the court of the learned additional chief judicial magistrate, Kollani Nodia, on 29th of December 2023. It appears that the charge sheet has already been submitted before the learned trial court. At this stage, it will not be proper to interfere in the matter. It will be open for the petitioner to approach the competent forum for relief if so advised. Next.
My lord, the period, my lord, may kindly be considered.
No, it cannot
My
be
lord, I shall
done.
be facing a 1 month limitation, 30 days. But if my lord, pendency of the
21.
writ petition, my lord, may kindly be considered.
21.
Section 14 of the Limitation Act, you can always take.
Always it can be taken.
Then
I appear on behalf of the petitioner, Lords.
21.
In this matter, Lordship, we are not being traced out the LR case number, TR case number.
No, there was a direction upon the BL and LR to produce instructions.
Who is appearing?
The state, Noel Banerjee was appearing.
Niloy Banerjee. Noel.
Make a phone call. Come back. Passing it over. Call the next one.
At 24, I'm for the petitioner. But the petition is an aggrieved wife, my lord.
Aggrieved?
Wife, my lord.
Wife?
Yes, my lord. File an application, my lord.
No matrimonial proceeding is
No,
pending here.
not my lord. It is an information under RTI Act, my lord.
You want information against your husband?
Yes, my lord. But my lord, regarding his salary, my lord, as my lord, he has filed, my lord, some case for divorce and other proceeding, my lord. My lord, I have filed, my lord, one application under RTI Act, my lord, relating to the information regarding, my lord, kindly come to, my lord, page 14, my lord.
Where does he work?
My lord, CISF, Joan, my lord.
CISF.
And thereafter, first appeal, second appeal, my lord, same reason, my lord.
What is the reason?
Yes, my lord, reason is this, my lord. My lord, this will, my lord, kindly come to, my lord, page 17, my lord, come.
17.
We regret, my lord, your lordship has got it, my lord.
Mm-hmm.
we regret that the information sought by you cannot be provided under RTI Act 2005 as Section 24 read with the second schedule of the Act exempts CISF from providing information except for the cases of corruption and human rights violation. The information sought by you does not fall precisely within the ambit of the two categories mentioned above. My lord, that is the first reason, and second reason is this, my lord. In second appeal, my lord, I have preferred also, my lord, first appeal, second appeal, my lord. In second appeal, my lord, the reason was that, my lord, kindly come to page 25, my lord.
Yes.
My lord, what happened, my lord? The appellant's representative stated that the appellant's husband was deserted her and had not been providing any financial help.
Decision.
Yes,
The
Perusal on record
authority is not
stating that the
intervening.
respondent furnished appropriate response to the appellant in terms of the provision of the RTI. There is no further intervention adjudication in respect of the, in this case, under the RTI Act. And my lord, my respectful submission before your lordship is this, my lord. This itself, my lord, it is a violation of human rights. And not only that, my lord, under the recent judgment of the Honorable Supreme Court, my lord, where, my lord, the three, my lord, offices, my lord, has been exempted under the RTI Act. Number one is ED, second is DRDO, and third is, my lord, I'm giving, my lord, the information, my lord, and third is, my lord, the...
Who are you representing?
The CISF, Your Lordship.
Yes, what will be your
Lordship,
submission?
the 5 things which she wanted to know was the date of superannuation, place of posting,
All
postal
personal
address.
information of the husband.
Person. Yes. We have also given her. We have given her.
Where is it?
Your Lordship, I'll just come to the date when she was told about it. Was in June 2009. She was informed about his posting that he's in Visakhapatnam. Currently, that he's posted in Visakhapatnam. That is the reason, Your Lordship, the page he was pointing at was page number 25. Before decision, when it's the respondent's reply, the last 3 lines it is written. Respondent stated that thrice since the year 2009, payslips of the appellant's husband has been provided to her outside the ambit of RTI. We have provided the payslips to her. In this case, the PIO responded in terms of the provisions of the RTI Act, and the FAA has also furnished the reasoned order. That is the reason that it was disposed of. Now, she was informed about the payslips in 2014 also. Twice she has been informed. She is also aware about the current posting.
My lord, kindly see the page 14. My RTI information, which has been...
No, the information were provided to you. The information
No information has been provided. My lord, kindly turn to page 23.
The information which was provided to her when on the page which you were showing, Your Lordship, page number 25, when she went in front of the commission, that is the reason that in... Just 1 second, sir.
Just a
1 second.
When will he retire, the husband?
Date of retirement, Your Lordship, I am not aware of.
Nothing has been provided to me. All the times they are saying it is, since CISF, it will not be provided. And lastly, my...
And pleases them, we can once again via reply, which was given in 2014.
1 minute.
To hide anything. There's nothing to hide.
1 minute. Page 24, I can see 4 questions. Information sought. Date of retirement, present place of posting, whether her name has been recorded as a wife.
Yes.
And what amount of money does he get per month as his salary? You please bring these for information, and
Your Lordship, we are ready to give them in writing whatever his salary is and where he is posted.
These are the 4 queries?
Yes. These are the 4 queries, my lord. Kindly see
no,
page
fine.
23,
It will be provided. Page 24? Achha. The petitioner seeks certain information under the Right to Information Act. Stop. The petitioner is the husband of whom she requires information for proceeding with her matrimonial case. Stop. The questions are appearing at page 24 of the writ petition. Stop. Learned advocate representing the authority is directed to produce answers to the said queries. Stop. 10th of June will be all right?
Your Lordship, kindly, this should be noted that we have provided, we can again provide.
10th of June will be all right? Achha. Learned advocate for the respondent submits that the information sought for were provided. Stop. Let current information be placed before this court on 10th of June. Service is taken on record.
Grateful, Lordship.
Part 40, my lord, morning, my lord, I need.
Yes.
Other side here.
Where is your other side?
Lordship, appearing virtually, your Lordship.
Yes.
Lordship, my junior is there. She will hand it over the letter. Bank has also served to the petitioner. They are ready to refund their EMD. This letter has also been served by hand today morning, your Lordship.
My lord, my agony is last para. We therefore request you to withdraw the petition and collect the aforesaid amount deposited by you as EMD upon prior notice to the bank by way of demand draft. My lord, kindly direct them to hand over the demand draft within a week and matter pending, my lord, after vacation. My lord, kindly.
Lordship, we are ready to hand over. Dispose of within a week, we will hand over. What the purpose will serve by keeping the petition pending?
Communicating letter of the chief manager of the bank addressed to the petitioners dated 16th May 2025 disclosing the intention of the bank to refund the earnest money deposit made by the petitioner is placed before this court. Stop. Copy of the same has been handed over to the learned advocate for the petitioners. Stop. It will be open for the petitioner to collect the earnest money deposit within a week from date. Stop. The writ petition stands disposed of. Liberty to mention.
Extremely sorry to trouble your lordship. Lordship had passed a recent order on 13th of May, your lordship. However, there is a typographical error, I think, in paragraph 10. If your lordship can check once. Lordship, it will take just one moment to rectify this. Your lordship can kindly keep tomorrow.
Paragraph 10?
Paragraph 10, your lordship. Third line.
Yes.
If it appears that the reasons, I may read out loud.
What should it be? I cannot remember what it is.
So within the stipulated, if it appears that the reasons given by the petitioners for not being able to complete the work within the stipulated time period, your lordship will be justified. That word is missing, your lordship. If your lordship
Which
reads,
word should be justified?
lordship, in paragraph 10,
Yes.
if it appears that the reasons given by the petitioners for not being able to complete the work within the stipulated time periods is justified is missing, then necessary order for cancelling the. So there is a typographical mistake, I am assuming, your lordship.
Let me just go through the entire order. If any change is required, tomorrow it will appear in the list as to be mentioned.
Grateful.
I'll go through it. Right?
Grateful, your lord.
It
is Passover, my lord. The state advocate is out of station, my lord. Kindly fix a date, my lord. He is in Delhi.
21?
Yes, 21, my lords.
It was passed over. State advocate is out of station?
Yes, he is in Delhi.
Who was the petitioner?
I am for the petitioners. I have informed to the state respondent. He is saying he is in out of station at Delhi.
Oh. And nobody assisting?
I do not know, my lord.
Please come. None appears on behalf of the state respondents.
Yeah.
Despite the date being fixed at the time of passing order on 6th May 2025. Stop. It has been reported that the learned advocate for the state is outside the state at present. Stop paragraph. The court is compelled to, now in such situation, the court is compelled to adjourn the matter because of non-appearance of the learned advocate for the state. Released on 9th of June.
Lord, kindly make it 10th.
10th.
Leave
10 तारीख है थोड़ा दिन.
10th.
Leave to Millard urgently move Millard to tomorrow Millard. Millard, this is Lordship knows the proceedings under Section 10(2) was of the Highways Act was initiated. Millard, demolition order was passed. Nothing communicated from the office of the subdivisional officer. Millard, yesterday the police officer gave a notice that they will Millard demolish it Millard on 22nd. We have already filed a statutory appeal before the Millard appellate authority. Now Millard 22nd, if it is dismissed, Millard, my appeal becomes infructuous.
21st it will appear. Leave the din, serve.
Yes, grateful.
My lord, I'm appearing for the petitioner,
I'm
led
appealing,
by Mr. Indrojit Dasgupta.
I am appealing for I'm appearing for the respondent number 5, Lordship. There was a direction upon us to file a report in form of an affidavit. I'm praying for extension for filing of the same. Lordship, may I submit one thing, Lordship? At page number 1, Lordship, what has happened in this case, Lordship, there was a mistaken transaction made by the petitioner in the bank account maintained with the respondent number 5 bank. Lordship had given us a direction that whether that particular there is any order from any competent authority to debit freeze that particular disputed amount or not. We have asked for instructions, Lordship. Upon instruction, I can submit, Lordship, that there is no instruction, there is no competent authority order for debit freezing the disputed amount of 6 lakhs of rupees. And that particular amount has been held in terms of the request made by the beneficiary's account that it was a mistaken transaction made by the beneficiary, made by the petitioner. And that is also reflected in the Ombudsman report as well, Lordship. So there is no dispute that it is a mistaken transaction made by the petitioner. It is my instruction, Lordship.
If the bank is also of the opinion that it was a mistaken transaction, then why don't you refund the money?
Lordship, the only difficulty is that the account, that particular respondent number 6, it is under liquidation right now, Lordship. So without any order, Lordship, we cannot refund the money. If your Lordship kindly directs the liquidator or the bank to
The
refund
liquidator possibly is not a party,
the party,
right?
we have
Why don't you give an opportunity of hearing to the liquidator or
have served the
notice
copy of-
upon the
yes,
liquidator?
Lordship. I had a word with her in the morning as well. I have sent her the virtual link as well. She was supposed to appear. I don't know whether she's here or not.
Nobody is there online at least.
I had a word with her. I have sent her the link as well. She was
Right,
supposed
because admittedly, the money is not of the respondent number 6 and the money should not be there, be it in liquidation or otherwise. So the money should go back to the person to who it actually belongs. Right.
My lord, kindly gives a direction upon the Yes Bank.
Or if your Lordship wants to hear out the liquidator, Lordship, the kindly keeps it up.
I'll pass it over.
Pass it over. I'll call the
Please do.
liquidator and
Please do. I'm passing it over.
Lordship, I'm just informing the liquidator that it will be taken up after 10-15 minutes or 30 minutes, whatever.
Please, your lordship. In this matter, I am appearing for the petitioner, your lordship. Petitioner, before your lordship.
Lord, I appear for the KMDA, respondent number 1 to 4. Lord, 2 writ petitions have been filed by the petitioners in connection with the same matter. One is challenging the show cause, one is challenging the reason order. On 6th of May, I am told, my lord, I was out of station, my lord, that on 6th of May, both the matters were adjourned. And so for the earlier writ petition is concerned, in which the reason order was challenged, that was adjourned till 9th June.
The last order.
No, last order is over here.
9th
No,
June,
last order
that
of the
matter
order.
is fixed. And
9th
this
of
matter,
June?
Yes,
this,
my lord.
this
Alright, I'll
matter
fix it on 9th.
Kindly see the last order of the other matter, 155 matter.
155
This is
03.
Yes.
All right.
My lord.
So I'll fix this on 9th.
My lord, my only prayer is that the petitioner before your lordship is 84 years old. So, keeping this in mind, kindly pass the order. He is 84 years old and he is suffering because he is unable.
So what is to be done? The one matter is already fixed on the 9th. Please come.
For your convenience, I brought the printout of the order of the other matter.
Do you let this writ petition? Now, it has been brought to the notice of the court that a further writ petition filed by the petitioner on self-same facts.
My lord, not on self,
but with a different prayer.
My lord, not on self-same facts. One is challenging the impugned reason order.
Being WPA 15503 of 2024.
I am challenging the impugned order, reasoned order, alleged reasoned order.
Has been fixed by the court on 9th June 2025. Stop. Let the present writ petition appear along with WPA 15503 of 2024 on 9th June 2025.
Let it I mean, naam ta diyo.
25 million I have for the bill. This is regarding payment.
Payment?
Your last can you see last order, 5th of May 2025. They have admitted my claim, they are supposed to make payment.
Yes. When the payment will be released?
Kindly fix it on 16th of June. Like the other matter, I will try.
It is a different matter. Those are all election matters.
I know, Milord, but that's what I'm saying. Seeking, Milord. I had a talk with them, Milord. It is under process because a new incumbent has come. So, Milord, that's what, Milord, he is seeking some time, Milord. So, Milord, kindly fix it 1 week after vacation, Milord.
2020.
I hope and trust that I will come up with some positive answer before his
2022, Milord.
আচ্ছা আসুন দেখি learned advocate representing the state respondent prays for fixing up the matter on 16th June 2025 within which positive instruction for payment can be obtained. On such prayer, list on 16th June.
Petition.
I'm for the petitioner in 26. For the last location, there was a direction to serve upon the new address of the private respondent lordship and also one through the police station. I have served lordship, but it again came back as addressee on hold.
Addressee?
This one is item on hold, addressee absent, intimation served.
Addressee absent.
Lordship, also there was a direction to serve through the police station, Lordship. What happened is, Lordship, when I served through the police station, they actually served it on the address of the original respondent only. So the service in that also is the same.
Greenfield ambience. Police did not accept
So,
it.
Lordship, actually it was served, but the address was of both the respondent number 8 through the police station address was given.
Yes.
So served to the respondent number 8 only. So that was the only thing I probably will be required to serve the police station one more time, Lordship. That was the only difficulty.
My lord,
We also sent one copy of the writ petition along with this notice also.
Lord, I am for the state, my lord. The report given to me.
The
PDF report, my lord.
give a copy to her.
Old report, my lord. Hand me. I don't know what is the position, latest position, my lord. Last page, my lord.
Please come. The private respondent would not be served yet. Stop. Let fresh service be effected upon the private respondent through the concerned police station. Stop. Released on 9th. Instruction forwarded by the SDO Kollani Nodia, dated 12th February 2025. February. Be written with the records.
I'm for the petitioner. Lord, matter relates to Lord unauthorized encroachment upon the PWD's land and in front of the petitioner's premises or affidavit of service. And my lord,
What is the instruction?
Instruction manner. Well, the Tumluk Highway Division asked for the demarcation of the government plot, my lord, from the BLR. Now, unless when a BLR report has come, my lord.
Where is your objection?
my lord, page 38.
38?
38.
38 is a Moja map.
Annexure P5.
It's a Moja map. Last page.
No, then thereafter.
No.
This is my lord.
P5
P5.
দিতে হবে না, আমাকে দিতে হবে না। Your pagination is incorrect. Page 36. This is page 36, and where is the proof of service of this letter?
Hello?
Proof of service of this letter.
But
Proof of service of page 35.
oh,
Nothing is annexed. Please come. The petitioner prays for removal of unauthorized encroachments. Encroachment over government land. Stuff. Though a representation is annexed to the writ petition made by the petitioner addressed to the assistant engineer, public works within bracket roads directorate, but there is no proof of service of the said letter upon the authority. Stuff. Next. In view of the above, leave is granted to the petitioner to file comprehensive representation with all supporting documents to the assistant engineer. Respondent number 3 herein. Assistant engineer, PWD roads.
Tomluk Highway Division.
Tomluk Highway Division. একটা কাজ করুন, অ্যাসিস্ট্যান্ট না করে রেসপন্ড নাম্বার 2 করুন, এক্সিকিউটিভ ইঞ্জিনিয়ার। Respondent number 2. কি বললাম ওটা? Representation before the respondent. Highlighting all illegalities. Step. In the event such a representation is made, the same shall be considered by the aforesaid authority. In accordance with law, after giving reasonable opportunity of hearing to all the necessary parties, at the earliest, but positively within a period of 12 weeks from the date of communication of this order, a reasoned order shall be passed and communicated to the parties immediately thereafter. Disposed, the report forwarded by the assistant engineer, Tomluk Highway Subdivision, PW within bracket Roads Directorate, dated 14th May 2025, be written with the record, service taken on record.
Though in 28, my client is not a party, but there are other matters, my lord, in the list which are connected to this, my lord. But before all my learned senior friends start, my lord, my only prayer is that if it can be taken up on the other side of the vacation.
All right. And are you taking steps in the meantime?
Yes, my lord, because
right,
my lord,
trying to find out a solution.
no, my lord, my client has taken a decision to prefer an appeal from this order, but my lord, we have not been able to obtain a certified copy for the last 11 days. We have applied. That's why I was, my lord, praying, my lord, to take it on the other side of the vacation, my lord. Thereafter, my lord, eventually, my lord, if steps are required, that's a different thing.
Happens in the appeal court is something different, but in the meantime, let the petitioner work.
Here we have no, we have nothing to say with regard to that. Your lordship already protected them, my lord. But as far as our consideration is concerned, there was a direction
But
to
then
consider.
do not take any steps so that the protection granted is frustrated.
Your lordship, only for reminding, I am appearing for the state in this matter.
I understand.
The restraint order is on the private respondents.
Yes, I understand.
And there is no allegation as far as the state is concerned directly that we are restraining anyone from working. And I have made that submission, my lord, consistently. But my lord, for the simple reason that we have not been able to obtain the, well, whatever may be the reason, my lord, if your lordship places it on the other side, my lord, then my lord,
let me hear once. Who are you for?
Yes, my lord, I am appearing for, my lord, one of the petitioners, Mr. Kingshukde, my lord, who has also filed a contempt application, which is not there in the list today.
All right.
But, my lord, I just indicate one thing. After my lord has passed, my lord's order in the writ petition, my lord, which is followed by contempt application, 2 orders passed, my lord, in the contempt matter, my lord, situation has become even worse.
Worsened.
Now, my lord, because of this, my lord, litigations that we have initiated, my lord, there is, my lord, a vindictive, my lord, attitude shown towards us. Messages are, my lord, being flooded, my lord, in the, my lord, WhatsApp group and everywhere. Milord, people are making statement that this order has no binding effect and they are not going to hear, listen to this order. Those everything we have annexed to our contempt application. We have used a supplementary affidavit. Now situation is even worse.
In fact, all these petitioners have been ostracized. They have been debarred. Virtually, they are now out of work.
There is a
from the date when your office passed the first order. I have also used this second supplementary affidavit. The directive has been issued by the contender number 1. Indicating that the federation's directives are binding.
Saying that we should be boycotted.
But who has passed the order for boycotting?
Contender number 5 in my contempt application.
But see, these contender number 1 or 5, they possibly are not statutory authorities.
No, but applying the Seward principle, Seward versus Patterson principle, the order is binding on them. They can't just turn a blind eye to the order passed by your lordship.
In fact, I can satisfy your lordship about the maintainability of the writ petitions here and now. If they allow me, I'll only show 2 judgments of the Supreme Court on the issue whether the writ is maintainable or not.
Tell me, the department was directed to take some decision.
Take a decision and place it before your lordship,
Today. What happened to that decision? Was the decision taken?
But decision has not been taken,
Why?
On the contrary,
on the plea that you will prefer an appeal.
We have started taking steps long back. Today is at least the 11th day.
Yes.
In the meantime, we approached the Honorable Division Bench also for our remedies without certified copy, etc. But it was not possible.
Why was it not possible?
The court directed that since you have applied, you wait for it. Certified copy you will get. But even throughout the last week, the department could not provide us with the certified copy. It's not that we have not taken any steps. We have taken steps. If required, I can show the documents also because
no, showing me will not help. What I can see is that there is an order you have not complied with and no stay order.
But
this is what I can see.
For placing the decision, I am praying a week's time. A week's time will take us on the other side of the vacation in any event.
But
so
what
I started
step
from there.
Have you taken to consider the representation?
We have received the representations. My learned seniors will agree that quite bulky representations have been given to us. But today I cannot place any decision before you.
My shooting is suspended.
But that's a different thing. State has not suspended. State has not suspended anyone.
Somebody's right to life is being infringed and state is not taking any step to protect the right of these people. This is what is troubling the court.
As far as today is concerned, we were supposed to place the decision.
Yes.
But that we are not in a position to place today.
Because if the decision is placed, then at least the court gets to know what is the stand of the state in this impasse that has been created. This is what I want to know. Otherwise, I do not know what is happening.
If my lord kindly
because the submission that is being made, they are not.
Kindly similar.
They are boycotted. They are ostracized, and all these things.
Kindly just see the materials ones because my contempt application is not there in the list today.
Is that to
let the contempt appear.
To counter these arguments, I really don't want to counter anyone's arguments, because
you are the state.
Yes. But if it is to be done, then the facts are to be placed before Lordship, that whose work, what work is on the floor, how much work is there on the floor or not. These submissions also I made on the last occasion, but problem is that I am not appearing for an adversarial party.
No,
I am not.
You have to take a balanced stand because you are the state.
My role is of that of a parents patria, but if I may put it in this way, I know this submission cannot be made, but if I place the decision with your lordship, then the other decision to carry an appeal becomes infructuous.
Mr. Bandyopadhyay should be our protector,
We are submission I am myself making it. Mr. Banerjee, I am making the submission myself.
The shooting went on without any hindrance.
There was no shooting.
Under no circumstances, state or the state respondents or the officers who are there in respondents, there are adversary to the petitioners in this matter at least. And that is also the role assigned by your lordship in the
yes,
order also.
Should not be.
It's a state's obligation.
You should see that the right to life and livelihood is not infringed.
At the same time, the right that as a respondent before lordship, my lord, the right they have, my lord. If the decision has been taken to exercise that right, my lord, kindly gives us at least a fortnight's time to come back. My lord. Fortnight will mean that those interim orders are already there, my lord. My other learned friends will
Who
address
is
your
going
lordship.
to ensure and how it can be ensured? You think by police protection he'll be able to do the work? Be reasonable.
May I just indicate one thing?
Mr. Bandyopadhyay is here. I can direct the police. But do you think it will be reasonable? Will it be feasible?
Try our hand. If it doesn't work, we'll come back, Millard, and we'll not bother your Mr. Mojumdar. The police Mr. Mojumdar, Millard is ready.
When I was, it is all identical material, but I tell your lordship was pleased to pass certain orders. These orders are not respected by the concerned contemners. My lord, I tell you, this is a peculiar case. When I was holding the conference yesterday, it appears really, literally, that something is really rotten in film industry. And your lordship can only exercise that.
The state has been directed to find out a solution to the impasse that has been created. Now, the state intends to prefer appeal, and possibly steps are being taken to prefer appeal. Now, that we cannot stand.
There is no appeal.
As on date, no appeal because certified copy was not available, and without the certified copy, this is what the submission is.
It is very strange that the state is taking up the cudgels on behalf of certain association. Absolutely, my lord. I'm sorry to make that submission.
Whatever.
Yes.
Now, on the very first day, I made it clear that the court was interfering only to the limited extent.
Yes.
That right to life and livelihood should be protected.
Right.
Nothing else.
Right.
Right. Now, how this is to be done? If somebody is stopping somebody or preventing somebody from working, your junior was making submission, let the police be there. Do you think that is feasible, that the police is going to stand there and can get your work done?
One submission, Federation is to be restrained to interfere with the affairs of the film industry. That order will suffice, because otherwise what happens, all these associations.
Firstly, what is the right of the federation? The court is not yet gone into it.
These the other associations are affiliates or constituents of the federations.
Right.
The federations is dictating their work. They said if you follow my direction, they have now come up with a code of conduct of 2022, since your lordships have said that the earlier code of conduct is no longer valid. That code of conduct also expired, but according to their own showing on 31st of March of 2025. Now they are reimposing the conditions which was on the submissions made by the
expired earlier.
Expired earlier. They actually restored the with a new code of conduct allegedly signed in 2022. It was not disclosed.
What is being done here? That a submission was made.
The petition suppressed that.
No, we are coming to that. Malad, a submission was made that the code of conduct is not there. Malad, thereafter, when the matter is pending before this honorable court, they come out with a memorandum of settlement or arrangement with the IMPA, that which is in fact in verbatim reproduction of the earlier code of conduct. Malad, your lordship was pleased to pass this order sometime in the month of April. Thereafter, 3rd May. So thereafter, my lord, your lordship will find from the records, find from the WhatsApp messages that constantly efforts have been made to, my lord, interfere with my client's right under Article 19(1)A and 19(1)G.
That has been taken care of in the order, and
yes, my lord, that is why, my lord,
specific.
Absolutely, my lord, I bow down to your lordship. But that order has to be enforced. The state says that the state is going to test this order in appeal. So, my lord, lordship will find that the nexus is apparent.
No, I'm sorry. Absolutely not.
Kindly take your
But as far as state's point is concerned, he has not seen my points in appeal.
Page 170 of the
State is never restrained by your lordship.
Your lordship has taken note of this code of conduct. That expired temporarily on 30th April 2015.
Right,
they introduced a new code of conduct, saying that this was virtually your lordship did not approve this code of conduct. Then how it could be my lord, enforced upon.
Reinstated. It has been
Code of conduct.
reinstated.
That expired in 31st March.
Then each and every term of the code of conduct has to be gone into like scrutinizing a settlement.
My lord,
There are-
how this
There
can
is
be
large scale
enforced upon?
exploitation which has been sought to be stopped.
This is a
18 to 19 hours of work on a day for payment towards payment of 8 hours of duty.
virtually a
My lord,
small
this
piece of
this is a kind, my lord, your lordship will find a cartel is working in this industry.
This has been
which
sponsored
is
by the
regulated-
producers.
which
This
is
is paragraph 12 from the
without
writ
any
petition.
authority of law.
Whose behest this writ petition has been filed?
Yes, it has
At the
been-
behest of the producers.
and
said
the
so? My
and the
question.
Let's come to paragraph 12 at page 8.
The directors are there, my lord, they can go to the box and say that it is there
This is a
instead.
facade.
In fact, they have been stopped in walking.
Milord, may I, Milord,
Mr. Roy is also present.
Is anybody representing the federation today?
only one indulgence.
Note number 5, I represent.
He is a federation.
You are the federation.
In the contempt, my lord, he is the respondent number 1, that is the secretary or president. He is, my lord, orchestrating everything.
Let the federation not interfere with the work of the petitioners. Whoever is the petitioners.
Order that has not been violated.
that has been
Milord.
violated and violated time and again. Every minute it is being violated.
Milord,
Order should be
Milord, may I?
complied with its true spirit.
Milord.
My lord, they are trying to circumvent the order. That also amounts to contempt.
Certainly it does.
Page, page.
Milord.
The federation do not interfere.
Of
If
this one.
the- any, my lord, anybody attached to the film industry,
That's the problem.
assistant director, my lord, the designers, nobody's work should be interfered with. Because those,
Why will the court look into these terms?
Mr. Bandhavadhyay wants
I'm saying this code of conduct cannot be
Certainly
used
not.
by the court.
I tell your lordship, there are 26 my lord unions or associations. My lord, this FCTWEI claims to be, my lord, at the helm of affairs. My lord, I have found out from the official website, I can show it to your lordship right now, of the Department of Information and Cultural Affairs, Government of West Bengal, that West Bengal Film Academy would act as an umbrella with regard to any dispute which arises in the film industry. My lord, kindly take this one. And the state is preferring that. Kindly take. So, my lord, today is I put the question to myself with all humility. My lord, today it has been marked. I'm so sorry, my lord. Today I put the question to myself with all humility. Has state authorized this particular FCTWEI or delegated its powers, which is otherwise apparent from their website, so that they can act as umbrella? Kindly take this is official website. Now I've downloaded it myself. So kindly take it from me that this is from their website. Kindly mark the functions of the West Bengal Film Academy. It has to be read in conjunction with the About Us page of this department. And what is the duty and responsibility?
That is exactly the reason the state was directed to consider.
I put the question.
Nothing.
With
Nothing.
the deepest of respect to Mr. Majumdar, state cannot be made answerable for preferring an appeal. My right to appeal. My right to appeal arises from where he files the application before your lordship. It's a statutory right to appeal. Number one. Number two, what he has handed over, I do not know. If I have understood correctly that he has an alternative remedy, he should approach the dispute resolution forum. If there is a dispute resolution forum according to the writ petitioner, he must approach them.
Once your lordship goes through this entirety of this particular website.
The dispute resolution forum is not taking steps in.
Yes.
But their cause of action in the writ petition is that there is a committee which we say is a non-existent committee which is not appearing anywhere in the books, in the records. Their entire writ petition is there, my lord. I can demonstrate from the pleadings. Their cause of action is not this.
Committee does not
exist. It's a committee where they say their pleaded case is that in July 2024 there was an impasse in which, my lord, the Honorable Chief Minister interfered and directed a committee to be formed. They say that this committee is not holding meetings and not removing the impasse. That is the cause of action in the writ
But the
petition.
department is there.
This is something else. This is not their cause of action.
The department is functional.
Department is functional, my
The
lord.
department should take steps irrespective of the fact.
My lord, I understand that. That is
appeal or not is different.
But that is, my lord, that is your lordship's directions dated 3rd of April.
Yes. From April till the 19th of May, see, nothing has been done. The contempt, in the meantime, one over here and the other there, 2 contempt applications have come up. Then what is to be done? If somebody's life and livelihood is taken away,
Rule is to be issued, my lord. Rule is to be.
I will not make one single submission on the contempt because I am quite aware that my clients are not contemptors in the contempt.
Absolutely.
So I will not make any submission with regard to the contempt.
But then, since
as-
you are a party in the
but
writ petition, you ensure that their
that is why I started by saying, because my lord, as an officer of your lordship's court, I understood on the last day when the contempt came up that what is falling from your lordship, my lord, and that is why the consideration which was to be placed on 19th May, that is today, was extremely important. I understood that. I did not make any submission with regard to that. But my lord, there are certain things, my lord, where the right is there of my client to prefer an appeal.
Only one indulgence.
That's why I started by saying that kindly post it on the other side of the vacation.
My learned
And in the meantime, my lord, all the production, direction work would be, my lord, postponed. Postponed at the whims and caprices of one association.
Yes, what is your submission?
Mr. Bandhavadhyay, my learned senior friend's client, have implemented us, my lord, contempt number 228, my lord, as party contemptness, alleged contemptness. But in the writ petition, we are not made parties. My lord, allegations have been made, we are not aware of this in a way. Because unless I get to know and I get to have the opportunity to respond to it, my lord, the contempt I'm a party, allegations have been made. I do not know what is the act of contempt, my lord. And the question is, my lord, the implementation of order, my lord, so far as your lordship's observation.
Why hasn't a copy of the application been
No, my lord,
served?
we are not a party. We are not a party in the writ petition.
Writ petition?
Yes.
In the writ petition, the federation is a party. Are you the member of?
Yes. Question is, my lord, my lord, in law, we expect certain certainties.
Yes.
Now, my lord, on the one hand, you say that these writ petitioners, that we have violated the order, my lord. We are the violators. Now, my lord, in the writ petition, my lord, what is the exact allegation, the premise of the writ petition? My lord, I do not know about it. Know about it means I do not get the opportunity. If your lordship wants to decide.
Was the federation represented?
Representation, I am the individual person. Kindly sees what are the parties. Tapan Kumar Ganguly, president, seen a video. What is the act of
No,
contempt?
in the writ petition, the federation was represented.
Federation was represented, but the other organization was a separate body. And Millard affiliated to the federation. Millard, they have individual complaint and contempt. Millard, these cannot be like this.
26
Millard,
children.
Mujumdar,
He is one of the 26 children of this parent.
That is not the correct interpretation of law.
Well, kindly protect us in the.
We are talking about the atmosphere, climate of intolerance in the industry on the one hand, and on the other, Millard, they are making allegations, wild allegations, without making us party in the
wild
petition.
allegations will be seen
in this allegation
representing the state
painted by their own imagination.
That an appeal is sought to be preferred against the order passed by this bench. Stop. It appears that
Vivid one. Not
wide order dated 3rd April 2025, the court directed the Secretary, Department of Information and Cultural Affairs, Government of West Bengal, to consider the issues raised by the petitioner with regard to the right to carry on profession independently. Stop. A decision was to be placed before this court today. Stop. The same has not been done.
No.
Stop. Prayer has been made to adjourn the matter till the other side of the vacation. Stop. The court on the same date, that is 3rd April 2025, directed that the respondent number 5 that is the Federation of Senior Technicians will not senior technician be restrained from interfering with the independent functioning of the petitioner in performing work, and none of the fundamental right to life and livelihood and the right to carry on business, trade and profession be interfered. Stop. Paragraph. A contempt application has been filed alleging that there is violation of the restraint order passed against the Federation. Stop. The members of the Federation have been impleaded as parties in the contempt application. Stop. Paragraph. The learned advocates representing the Federation and the other parties in the contempt application deny the allegations made in the contempt application. Stop. Paragraph. For the time being, the court is not entering into the allegation and counter allegation of the parties. Stop. As it has been submitted that the order of the court is not being complied with, accordingly, the
subsequent order was also passed on the 7th May.
Accordingly, the Secretary of the Department of Information and Cultural Affairs is directed to ensure that the fundamental right of the petitioner is not infringed in any manner whatsoever. Stop. None should interfere with the right to life and business, trade and profession of the petitioner. Stop. If required, the Secretary may take the help of the jurisdictional police station to ensure that the work of the petitioner is not interfered with in any manner, and the petitioner can perform the work independently without interference from any party whatsoever.
And we may register our complaints with the Secretary in the meantime.
If the petitioner faces any difficulty or interference, the petitioner shall report the same immediately to the Secretary of the Department. Stop. And Department who will take immediate remedial steps on receipt of the complaint, if any.
Another thing, that no technician should be prevented. Otherwise, all technicians
This is
should
what
be
is happening,
separately prevented. No technician should be prevented to work with us.
I am for respond number 10 to 14, before your lordship passes that, bear with me for 2 minutes. I am not a party to the liquidation, so I don't have an opportunity to come.
Who are you?
I am these technicians that Mr. Bandyopadhyay wants to see.
No, they are not the technician. They are the association of
You certainly cannot stop somebody from working.
They are the stopping.
If you are not stopping, don't stop. You will not be bothered by the order. Then the
modifying a section. They are not the technicians, they are the secretary and president of their association.
And modifying a settlement.
The
Lordship has provided an order that tomorrow, if I don't want
see, today one technician is coming.
Yes.
Tomorrow somebody else will object.
No,
And
only
each
thing
and every
what
day
they are
this
doing,
cannot be done.
I tell you, Lordship,
that
this submission,
association is stopping the technicians to work with us.
this
If the technicians, they should not be stopped.
Millard, kindly,
You
One
can,
minute.
you have been given liberty to approach the secretary. You approach the secretary with whatever prayers, because do not restrict to the technicians.
No.
One thing is
What
very
happens,
clear.
what they can do cannot do directly.
They are doing it indirectly. I can understand.
Millard, same applies to us.
Supplementary affidavit. The supplementary affidavit. What they have done.
You're forcing me to work for you.
Yes,
What they have done.
now one of the nexus is apparent. I am grateful to Mr. Banerjee.
Yes.
I am grateful to Mr. Banerjee. Yes.
Millard, this will
16th I am relisting it.
But Millard, it is our fervent prayer before your lordship. Millard, kindly decide the list, Millard, forever, Millard.
Why?
Because
Appeal
Millard,
will be preferred.
Go on.
Go before the division bench.
Millard,
against the
28,
interim order.
Because
Write it
my
out.
lord, what has
28
happened,
is
my
the
lord?
contempt.
20.
Item 28 is the contempt. Sole
Right.
contempt appearing in the list.
Yes.
38 is the lead rate.
But there is
Item
another
38.
contempt in item 43.
And
which is
thereafter,
not
my lord,
appearing.
49 to 60.
49.
No,
49, I'm
49 to 61, তাই তো?
Yes.
38 will also appear on the 16th of
16th.
June.
Yes.
পরের আইটেম গুলো
Right.
বলে দাও 49 থেকে
49
1 minute. Divya Babu.
49 to 61.
1 minute, please. 38 is the writ.
38 is the rate.
And
That was the lead rate.
In 49, there is a contempt application which is not
appearing. Na last item টা দেখো.
38.
61.
Let this matter appear on 16th June 2025. The respondents
61, my lord.
49 to 61 তো? And same order of 38 and 49 to 61.
The order passed today in CPAN 698/2025 in WPS 7566/2025 shall be applicable in the instant case also. ঠিক আছে, এটা 38 হলো, এটা এবারে হচ্ছে 49 to 61. Same order will be there.
One thing, my lord, jurisdictional police station, your lordship has indicated.
Jurisdictional police station.
Police stations, my lord, because
Any?
outdoor shooting.
আচ্ছা, পুলিশ স্টেশনস, যেখানে জুরিসডিকশনাল পুলিশ স্টেশন বলেছিলাম ওটা স্টেশনস হবে। And where is the other contempt you say?
My lord, in 49, my lord. Item
49. Give the number so that it can appear.
Will give, my lord. Hey, number.
49 contempt CPAN number.
CPA.
49 এতে একটা নোট করে নিন। Let's CPAN.
তাহলে সার্টিফাইড কপি দিচ্ছেন।
My lord, I have given the number, my lord.
CPAN such and such appear along with the writ petition on 16th of June.
Grateful, my
Same order as 38. শুধু CPAN-টা যাচ্ছে ওইটার সঙ্গে 49 এর সঙ্গে।
Lord, through your lordships, may I request the file to be sent down to the department, my lord, of item number 38.
Send down.
Great.
এটা পাঠিয়ে দেবেন তো।
Grateful, my lord.
Deeply obliged.
Lordship. In item number 23, learned liquidator is online, Lordship.
Is the petitioner there?
Petitioner is here, Lordship.
দেখি একবার পাসওয়ার্ড যেটা হয়েছে।
My lord, 29.
23.
23. Oh, 23.
Where is the liquidator?
My lordship, I'm here. And I'm grateful for you to allow me appear in physical.
Certain amount
Virtual mode.
Certain amount has been wrongly credited in the account of the respondent number 6. Now this money is to be refunded. Respondent number 6 is in liquidation. That is the reason you are required to address the court. All right.
My lordship, right. My lordship, actually, just to inform you, I had received this mail from Ms. Ganguly office, and unfortunately, it went to my spam account, so I was unaware of the whole matter. And when I was going through this, I just found that this matter relates to December 23 period somewhat, to which the books I don't have access of. So primarily, I will have to get back to Yes Bank and get their confirmation whether this amount had actually been credited to the account of Salasar Exim or not.
Learned advocate for Yes Bank says it was, and it was inadvertently done. So whatever communication you need from the bank will be ready to communicate. And in the meantime, please return the money. Please come.
Lordship, but like this matter, this company was under insolvency on July 23. So I'll have to take confirmation from the erstwhile officer of the court during that period.
Achha.
Mr. RP.
Learned advocate representing Yes Bank submits upon instruction that the subject sum was admittedly credited in the bank account of the respondent number 6 erroneously. Stop. The money is not of the respondent number 6, but the same belongs to the petitioner. Paragraph. The respondent number 6 is currently in liquidation. Stop. The liquidator has been heard virtually. Stop. The liquidator is not aware as to whether the money was actually credited in the account of the respondent number 6. Paragraph. As it appears that the bank has confirmed that the money was erroneously credited in the account of the respondent number 6, accordingly, the bank is directed to refund the said amount from the refund the said amount to the petitioner. Stop. The official liquidator will act in coordination with the bank to ensure that the money which the petitioner is rightly entitled to is returned in his bank account without any unnecessary delay. Step. The money should positively be credited in the account of the petitioner by 30th of June 2025. Writ petition disposed.
Lordship, only one indulgence. Instead of confirmed that the money has been erroneously transferred to the respondent number 5 bank, Lordship, can it be, that was my verbal instruction, Lordship. It is observed in the Ombudsman order that bank has confirmed that they have marked lien in the beneficiary's account for the disputed amount after receiving request from the issuer bank dated such and such. So this has been confirmed that he has
confirmed.
Whether it's erroneously or that's a verbal instruction I had.
It has to be, otherwise how somebody is not entitled to the money. Call the next one, please. 29.
Yes.
May I recapitulate the matter in short?
The Indian bank is holding back rupees 20 lakh.
Yes, my lord.
Financed by the bank to protect the bank's interest. It was found that the transaction with the petitioner and his wife was under the scanner of CGST authority. Yes.
Yes, my lord. The fact is, my lord, the petitioner, my lord, is a small businessman. He belongs to the MSME category and he opened a cash credit account with the Indian bank, my lord. And the loan sanction was 20 lakhs. My lord, against the 20 lakhs, there was a security. First there was a principal security, my lord, of his book debts and his stock, which is amounting to 42 lakhs, my lord. Then his flat was mortgaged, my lord, and that is amounting to 20 lakhs. So total, my lord, it is in annexed here, my lord. Total security for the 20 lakhs was 63 point something, my lord, lakhs. And the coverage was more than 300%, my lord, of the exposure is covered by the security. Now, my lord, suddenly, my lord, on 16th of December, the petitioner issued a check to the pro forma respondent number 6 for certain goods which he has received. Now, my lord, that is at page 43. And my lord, on next day, my lord, the pro forma respondent number 6 bank returned the check, dishonored the check, saying insufficient funds, my lord, which is at page 44, if my lord sees it. It's categorically stated that the check is could not be honored, my lord. Funds insufficient. But at that time, my lord, there was no insufficient funds. He had not exceeded his limit of 20 lakhs. So, my lord, when the petitioner wrote a letter to the bank's reply, my lord, was at page 53. My lord, they said that there is some investigation against one Meena Singh. And because the petitioner had, my lord, page 53. There were some investigations by the GST authorities against Meena Singh. And because the petitioner had some transactions with Meena Singh, so therefore, my lord, they considered it that they will put a hold on this account, my lord. But there was no, attachment by the authorities to prevent the bank from disbursing the money to me. Now, my lord, kindly see page 53. My lord, 1, 2, 3, 4. My lord, third paragraph. In this regard, we inform you we have received letter from Office of the Principal Commissioner, CGST and Central Excise, etc., for provisional attachment of property of under Section 83 in the account of Mrs. Meena Singh for suspicious transaction. So next. So we have temporarily hold rupees 20 lakhs, which is financed by Indian Bank to protect the bank's interest as there is transactions between Messrs. Sonal. Sonal is, my lord, the petitioner, and Mrs. Meena Singh, reflecting in account statement. And Mrs. Meena Singh's accounts transactions are under investigation in respect of suspicious transaction by CGST. Now, as per sanction ticket, bank reserves to itself the right to cancel, suspend the limit at its sole discretion without assigning any reason whatsoever. Now, my lord, pausing here for a moment, my lord. There is nothing against me from the authorities. My lord, I can have any transactions with very different persons. If an investigation is going against that person, my lord, that does not mean my account has to be held. And my lord, they are public sector banks being states within the meaning of Article 14.
Let me hear the bank once.
My lord, they have given a reply. My lord, they have submitted. My lord, I'm
Our report is on record. We filed it on the last day.
My lord,
Yes, what is it?
My lord, I'm taking your lordship through that report.
Page number 5 of my report is essentially my stand. I won't make any submissions beyond my stand at page number 5. Mullah. That's it. I'll leave it to your lordship.
My lord, paragraph 8, kindly see.
Yes.
It is stated that the bank has only temporarily put a hold on the said loan amount of rupees 20 lakhs. However, the operation of the loan account has not been put on hold, neither there is any freezing of the account. Even pausing here for a moment. My lord, this is indulging in double speaking. You were saying it is not frozen and you are putting a hold on my account. It is most humbly submitted that although there is no direct attachment letter on the loan account in the name of Sonal, however, considering the fact that there are direct transactions between the said loan account and the account of Srimati Meena Singh, the loan amount has been put on hold before disbursal as a precautionary measure so as to adequately protect the interest of the bank. Now, my lord, coming to the last paragraph, it is further stated that the bank is also willing to forthwith remove the hold on the said amount if the petitioners submit the NOC of such provisional attachment from the Central Excise Department subject to renewal of loan account. My lord, there is no attachment against me by the Central Excise or CGST. So why will they give me a NOC?
Where is this attachment? Any document annexed in support of attachment?
Yes. Yes.
Yes. My lord. My lord,
Subject to renewal of the loan account. Has the loan account been stopped from operation? Nothing of the sort.
Only
Isn't
with
it?
respect to the operation, my lord. Whatever
20 lakh.
My lord,
20 lakh.
20 lakhs. To the extent of 20 lakhs, which is the sanctioned amount. There's a provisional hold on the disbursal of the same. There is no other transactional, my lord, or
So what
freezing.
does this subject to renewal of the loan account mean? How is it
That is
renewed?
if there is a renewal required, if there is a period clause in that particular sanction letter. So, and if it is in the verge of expiring or anything like that within this time period, if it is to be disbursed, if that is there, then they can make a representation asking for that to be renewed. It's only a technicality, my lord. I don't think that prejudices the rights of the petitioner in any manner.
And where is the provisional attachment from the Central Excise Department?
But I have a copy of that. May I hand it up? It's not, I don't know if it's a part of the writ application. This letter is not a part of the writ application.
Then it should have been there in your report if you are relying on it.
May I, my lord, 1 second.
Check up.
Well, it's there. Page number 21 is slightly, my lord, illegible, at least the copy that's been given to me.
Right.
It's the same letter that I'm handing up, my lord.
Then don't hand up if we can.
So kindly looks at page number 21.
21. Central Principal Commissioner,
The
Central
Office of the
GST.
Principal Commissioner, CGST. I'll just read the body of the letter, my lord.
Provisional attachment of property under Section 83.
Of the CGST Act 2017.
Right.
It is to inform you that Messrs. Sunrise Traders Company, legal name so-and-so, is a registered
taxable person.
Uday Mahato.
I have nothing with him.
is a registered taxable person having GSTN number so and so. Proceedings have been launched against the aforesaid person as they have indulged in contravention of the provisions of the CGST Act 2017. In course of the investigation, it emerged that they have made transactions with Srimati Meena Singh, which appears to have been used for dealing suspicious transactions. From the record, it has come to the notice that Srimati Meena Singh holds an account with your bank having account number so and so. In order to protect the interest of the revenue and in exercise of powers conferred under Section 83 of the CGST Act, I, Manoj Kumar Kedia, Principal Commissioner CGST and CX, it says, Kolkata North Commissionerate, hereby provisionally attach the aforesaid account. This is with respect to, my lord, transactions that may have been carried out with Meena Singh. The petitioner, if I'm not wrong, is subject to correction, is the husband of Meena Singh.
Doesn't matter.
No, may not matter. Just to bring, may not have any bearing on the case. But I'll have to indicate this.
Is this account number involved over here? 6843882183. Having account number?
No, my lord. Meena Singh's account is not our account, my lord. Meena Singh has a separate GST, is a separate entity having a separate GST registration and also a separate PAN.
Well, I have clarified in the report, paragraph 8, that the petitioner's account, there is no notice. Have to be very candid. Well, I'll not beat around the bush. There is no provisional attachment in respect of the account of the petitioner. But because there are fraudulent or whatever suspicious transactions that have been noticed in the account of Meena Singh, which forms a part of page number 21, provisional allotment of Meena Singh, for abundant caution, my lord, we've done this, and we are ready to, my lord, forego it if provided, my lord, they get some kind of an NOC, even with respect to Meena Singh's account. We are willing.
Why will the petitioner get an NOC in respect of his wife's bank account?
That is a question.
Is there any requirement?
No,
Only because there is a marital tie between the two, you expect that?
That I'll not unnecessarily argue that case. I'll not. Lordship will kindly record one thing. 7, 8, and 9 are my submissions. That is it. I'll not.
My lord, one submission may I make, my lord? I'm praying. My lord, the thing is that, my lord, when they dishonored my check, kindly note, they said insufficient funds. And my reputation, my lord, has sunk, my lord, to the ground. My lord, nobody is doing business with me. And from December 16th, my lord, till now, I have not been able to operate this account. I have no disbursal has been made. And my lord, it is affecting my fundamental rights under Article 14, 19G and 21. My livelihood, I cannot. So I am only praying, my lord, this whatever the hold, they are holding the disbursal, that should be withdrawn. And I'm also praying, which I leave it to your lordship, for compensation and cost.
Not for compensation.
I leave it to your lordship.
It's a banking transaction. It's a case for damages for them.
Yes.
It's a banking transaction. I'm a banker to them.
Petitioner is aggrieved as the bank has kept on hold a sum of rupees 20 lakh.
Only the loan account, not the sum by itself.
Which is secured by
60. There's a sum that was sanctioned in their favor. We've withheld the loan account from being accessed. We haven't held liquid cash against them. It's not a bank account or a current account or a savings account.
Loan amount.
Cash credit. Cash credit.
Of 62 lakhs. 63 lakhs.
The loan amount of rupees 20 lakh.
Bank has already secured its situation.
On the ground that the bank account of the petitioner's wife had some fraudulent transaction. Stop. There is no allegation against the petitioner about any illegal or fraudulent transaction. Stop. Only because the bank account of the petitioner's wife was found to be involved in certain transactions which are under investigation by the
GST department.
GST department.
CGST. CGST department.
CGST department. The bank has put on hold on the loan amount. Stop. The report filed by the bank report. Now, affidavit filed by the bank discloses that the bank is willing to remove the hold if the petitioner submits no objection certificate of the provisional attachment of the petitioner's wife's account from the department, concerned department. Paragraph. I have heard the submission made on behalf of both the parties and have perused the materials on record. Stuff. Admittedly, it appears that the loan account of the petitioner has not been found to be involved in any type of fraudulent transaction. Stuff. There is no restraint order in respect of the loan account of the petitioner from any authority whatsoever. Stop. The petitioner's wife has an independent loan account and a bank account. Stop. The same may have been under investigation, but that reason, but the same cannot be a reason for putting on hold the loan amount of the petitioner, in respect of which there is no adverse remark from any quarter. Stop. It was absolutely improper for the bank to restrain the petitioner from utilizing the loan amount. Stop. Next. In view of the above, the instant writ petition stands allowed by directing the manager Indian Bank to immediately remove the hold put on the loan account of the petitioner and permit the petitioner to proceed with the, not proceed, but operate the loan account in accordance with law. Writ petition disposed.
And my lord, they will disburse the amount, my lord, now.
Well, disbursement, there is a mechanism
You
given.
will be permitted to operate it, which includes
In
disbursal.
terms of the letter of sanction, they'll operate.
Whatever is there, in accordance with law.
I'm grateful.
I'm grateful, my lord.
My lord, I'm for the respondent of this one.
Your Lordship, I'm appearing on respondent number 5, led by Mr. Arun Kumar Mohanty. Your Lordship, this is the death certificate. Your Lordship,
My lord, on the last occasion, your lordship directed me to furnish a status report, my lord. The status report, my lord.
Hearing took place before the ADMLR.
Yes.
Lordship, this is the death certificate.
Annexure 3, my lord, I've folded it, my lord. It becomes easier for your lordship.
Is the petitioner not represented?
No, Your Lordship.
Petition.
Respondent 5.
A joint FHTD? FHTD, what does this?
Freehold title deed.
All right, was issued in favor of Gopal Mondal.
Gopal Mondal is the
And
son
mother.
and mother.
Fulmati is the mother.
Yes. Instead of Tejen Mondal, Gopal Mondal's name has been incorporated. That could have been easily done, my lord. I fail to understand.
Srimati Fulmati applied for rectification. On the other hand, Gopal has claimed that the deed was issued in his name and his wife Boishaki Roy Mondal's name.
And the mother has obtained an injunction, my lord, from the civil court. Only because of that reason, they are not passing any order. That has nothing to do with this, my lord. That is regarding possession of the property.
You know what Gopal did?
Yes.
Gopal
He has also
went on to say that
he and his wife is.
name is the same.
Yes. Very.
What should be done?
My lord, if your lordship directs, my
Private
lord, take.
respondent, what is your submission?
Your Lordship, since Gopal Mondal is not no more alive, let
dead.
the petitioner file a substitution. So we'll come back on the next date.
Substitution has been filed.
I'm not aware of that, Your Lordship.
Copy not served.
No, Your Lordship. As per Your Lordship's direction,
Gopal is not appearing because he's expired, and the mother doesn't know that his son has expired.
Lordship, this is a death certificate. I've got it.
Very sorry state of affairs, my lord, going on. A very sorry.
Let me see. Now I do not know what the mother will do. 2nd of April 25.
Yes, Your Lordship.
Spouse is Bishakha Roy Mondal.
Yes, Your Lordship.
Name of father is Tejan Mondal. That means the husband's name is Tejan Mondal. It is very clear. Please come. None appears on behalf of the petitioner. Stop. Learned advocate representing the respondent number 5.
My lord, your lordship can certainly direct the ADM so that he can initiate some inquiry and find out.
What to inquire?
He has to go to the place. He has to find out who is the original person, actual person.
No, you have the records.
We have the.
Why will you go personally to a place, see who is there? That is not your work.
He is putting allegations. No? So
allegation regarding what?
That the father's name and the son's name are the same.
It cannot be. Not the father's name, son's name, the mother's name and the,
even the mother's and daughter's name also.
Because see, the death certificate records the name as Bishakha. It does not say alias Fulmoti.
Can we have a copy of the death
Certainly, give a copy.
Lordship, I have only one copy right now. I'll give a photocopy. It's with.
Submits that the respondent number 5 has expired on 2nd April 2025. Stop.
Name of the mother.
Copy of the death certificate of the said Gopal Mondal has been placed before this court. Stop. It appears there from that the name of the spouse of the deceased is recorded as Bishakha Roy Mondal, and the name of the father of the deceased is recorded as Tejan Mondal. Stop. Paragraph. From the report filed before this court by the ADM within bracket LR and RR, South 24 Parganas, dated 27th February 2025. It appears that
as husband of the petitioner,
a joint freehold title deed was issued in favor of
the petitioner.
Yes, but you can say
now joint cartoon. A freehold title deed was issued jointly in favor of Gopal Mondal and his mother Fulmoti Mondal. আচ্ছা গোপাল মন্ডল তার পাশে লিখুন son of late Tejan Mondal and his mother Srimati Fulmoti Mondal, wife of late Tejan Mondal. Stop. The name of the husband of Fulmoti was inadvertently recorded as Gopal Mondal. Stop. Fulmoti applied for correction of the name of her husband. Name of her husband in the title deed. Stop. Gopal claimed that the deed was issued in his name and the name of his wife, Bishakha Roy Mondal, also known as Fulmoti Mondal.
Here, the mother's name is not written.
Father's name is written now.
Stop.
Son of Tejan Mondal.
Correction is regarding, there is regarding this only.
Go through this last line.
The
Gopal Mondal in place of Tejan Mondal.
ADMLR
They're claiming Gopal
uh,
Mondal कोई नहीं है. Tejan Mondal. हाँ.
though initiated proceeding to resolve the issue, but
This is unnecessary.
after being apprised of pendency of a civil case, civil suit
Why Vishakha Mondal's name he also put
before the learned trial court, comma,
इसको क्या करूँ?
the
He is claiming
said authority
That is when that is
disposed of the matter by holding the issue to be sub judice before the civil court. Stop. Next. As it appears that the respondent number 5 has expired, comma, steps ought to be taken for substitution. Stop. Next. Let the matter be delisted for the time being. Liberty granted to the petitioner to take steps for substitution of the deceased respondent number 5.
But even in the death certificate, my lord, the father's name has been stated.
Yes.
Tejan Mondal.
There is no dispute with the father's name.
Only the mother.
Alias is creating the problem. Next.
So presently it is delisted, my lord.
It is delisted. Let the substitution take place. Then only we can proceed.
My lord. I'm grateful.
complied in all the matters. We have complied with the removing the name from the city attachment. My lord, in the 2 matters, they were. I'm filing the report there too. I have served the copy also. 7.
Lordship,
And my lord,
it
this is
is-
the customer satisfaction letter issued by the company, wherein they have said that we would like to draw your attention that the above accounts open process is completed by the help of your branch officer. We have no grievance against the branch.
Lordship, I am so grateful that after my initiation, taking step to file writ petition, then they compel to
Well,
Lordship.
the grievance of the
Lordship,
petitioner
my-
appears to have been redressed by
Lordship-
the bank.
Lordship, it is my humble prayer before your Lordship. Kindly give me liberty to file case before the competent court of law for consideration of compensation because
Of the harassment caused to you.
lots of
Okay.
harassment. There is a lots of
In
harassment.
the report, my lord may see in the full
Deliberate action, my lord.
action, we have taken up the matters. We could retrieve only the mail records from 2023. From 2023, we have been putting a mail to SEBI for confirmation of the order, but the same was not received from the end of SEBI. For that reason only, we could not. Yes.
Appears to have been redressed. Stop. Learned advocate for the
At the last
petitioner submits that
my lord,
because
under
of the
complete
illegal
dormancy,
act
there
of
was
the
no
bank,
attachment in
comma, the petitioner has been made to suffer immense harassment and financial loss. Stop. The petitioner seeks compensation for the damages caused. Stop paragraph. As the petitioner has as the issue pending before this court has been redressed, comma, the instant writ petition is disposed of by observing that it will be open for the petitioner to approach the competent forum for obtaining necessary compensation in accordance with law if so advised. Report of the bank filed by way of an affidavit be retained with the records. Are there 3 matters?
Lordship,
31.
31 to 33.
31 to 33, 3টে আলাদা আলাদা রিপোর্ট, 3টে আলাদা ফাইলে যাবে।
My lord, in the last well-planned matter, there was no attachment. there was only dormancy in the account, so that account opening process is still.
Whatever, his grievance has been redressed, it is recorded and disposed of.
Lordship, I am again grateful to judiciary and Lordship also.
Yes.
For the petition. There was a direction passed by your Lordship on 8th of April 2025. This is regarding my appointment of guardian in respect of mentally disabled person or persons with mental.
Milord, there was a direction, Milord, upon the Milord DM to pass a recent order.
Some development is there.
Milord, may I, Milord, hand over a copy.
In a positive way, the development is there. That is yet to be completed.
Yes, yet to be complete. I am not taking this as an adversarial litigation, Lordship. It's a very sensitive issue. Lordship, Milord, this is what they have done. The DM has given me this copy.
Are you aware of this order?
Yes.
All right.
So they want some further time. So Lordship may kindly give a
Further
time
to
pass a final order, Milord. Since they want some expert opinion. Kindly, this is last paragraph of the second page. Second page, last paragraph.
NCC in its meeting held on another year reconstituted the case in terms of solemn order.
Copy the page.
In the meantime, the lady is been taken care of by the petitioner.
In a mental institution.
In a mental institution.
Lordship may kindly give a time frame so that they can reach a decision, Lordship.
Achha, please come.
Without guardianship, we cannot proceed.
Pradeep, the order of the district magistrate, not 24 Parganas, on behalf of the local level committee, not 24 Parganas, signed on 13th May 2025. Placed in court today is retained with the records. Stuff. It appears that the authority intends to obtain expert opinion to finally dispose of the prayer of the petitioner. Stuff. Paragraph. On the request, on the prayer made by the learned advocate representing the state respondents, hearing of the instant writ petition stands adjourned till 11th June 2025. Stuff. The further decision taken by the district magistrate in this regard shall be placed before this court on the adjourned date.
Good. They have sought for instruction from the CMOH, I believe so.
No. Not CMOH.
They are
from the medical college.
Principal of Medical College.
Medical college.
Have held a meeting.
And the commissioner of somebody else.
They are under process, Lordship.
I believe, Malad, it would be short enough.
Lordship, I appear for the respondent, Bank.
May it please your Lordship, I am for the petitioner. This is that case, identity theft of PAN and Aadhaar number.
Namesake Shubhadeep Mitra.
Lordship, I would like to apprise your Lordship, my lord, with some of the facts of the case. If your Lordship may kindly takes up, my lord, page number 29. This is the complaint made by the petitioner before the Ombudsman, your Lordship. Lordship, the petitioner has stated that the Ombudsman did not entertain, my lord. If my lord kindly comes to page number 30, I believe, the page number is not there. Lord, there is a complaint, my lord, dated 19/1/2024. My lord, this complaint is not annexed. Now, if your Lordship kindly turns to page number 33, the Ombudsman to a further complaint, my lord, has decided
Yes.
My lord, the observation of the ombudsman is at, my lord, at number 2, where it is stated that from the documents uploaded by PNB, it is observed that the signature on the loan application sanction letter issued by the bank appears to tally with the specimen signature of the complaint in naked eyes. Further, the loan was sanctioned by considering the Aadhaar and PAN details which tally with the Aadhaar and PAN of the complainant as submitted by him during KYC updation. Apparently, no observable deficiency in services by the bank could be evidenced. However, unauthorized transaction of such natures require detailed investigation by law enforcing agencies, and RBI being summary forum in nature is not bestowed with such power. Lordship, no challenge to this order. Malad, they have preferred complaint before the police authorities. Now, Malad, the police will be able to say whether there was a fraud or not. Malad, in our naked eyes, Malad, there has been no fraud. Malad, on the last occasion, I do not know if a copy of the original application was handed over to your Lordship or not. If your Lordship kindly tallies, Malad, all the signatures, Malad, are this
paper book about?
Malad, this is the original application which has been filed by the bank before the Death Recovery Tribunal, Malad, for their recovery of money.
Are you aware of this?
Yes,
My lord, we do have a copy, but it is not very eligible. But the signature portion and the signature of his passport, they don't tally.
My lord, how will the bank be able
My
to
lord,
know this?
this is just what she submitted right now for the bank. That with even with the naked eyes,
Is the police
Police-
conducting any investigation?
police has just filed.
I have a report from the police, my lord. My lord,
What
the
does it
police is
say?
conducting an investigation, my lord. They have registered a cognizable offense under BNS, my lord, and my lord,
Against whom?
against my lord,
My lord,
my
no,
lord, it's in the second page of the report, my lord.
my lord,
They have registered. I do not have the copy of the.
there's a later edition. If your lordship goes through that paper book, that the original mortgage was with somebody from Kodamtola, Howrah, and the property has been bought in Moheshtola. After I had complained, the writ petitioner had complained, raised his voice, made the police complaint, his address has been added to this proceeding. That is when we had to come before this honorable court. Before that, his address was nowhere there. My lord, one financial institution has already given him a clean check and his CIBIL score has been rectified from that end.
My lord, one more thing.
See, Piramal Housing Limited is a private entity. Punjab National Bank is not. So, Punjab will be more accountable to their actions, isn't it? If somebody has removed the name from their records, that does not mean that Punjab will also do it.
About only Lordship.
My lord,
Lordship,
Piramal
Pakistan
Housing
inquiry
is
will be
presently
between
the
the recurring
biggest
cases
recovery
registered.
house, finance house in India. Piramal Housing is part of Piramal Finance. They are like Arc Recovery. They are one of the biggest recovery
Maybe
companies
during
in India, and
investigation and
they are outsourced even by the nationalized banks.
And then they must be having their own mechanism to find out whether the petitioner was involved or not. PNB does not have.
My lord, may I have an inspection of the original paper book?
Yes,
Please do.
Yes.
Now, what is to be done over here? See, all disputed questions of facts. How can the writ petition be made tenable? Who is going to identify and take steps to confirm the actual
And, my lord,
identity?
one further thing, my lord, he has, my lord, there is a
If this is the paper book, this is exactly what the photograph is coming. Even in our copy, it is totally
it is a
blacked out.
photocopy. It's a photocopy, my lord.
The photo above is clear, but it is only with respect of Shubhadev Mitra, it is blacked out. My lord, that is the reason why, my lord, I had prayed for certiorari.
My lord, if the record,
You want the original
like it is
loan
mortgage wages, my lord,
application?
we will be having in our bank. My lord, the original application, my lord, the original application is filed before the DRT. Now, my lord, the title deed that is being in dispute here, my lord, the bank will be having the original. If your lordship so wants, my lord, I can bring. My lord, only one thing that he has taken the loan, allegedly, my lord, the petitioner has taken the loan, my lord, in order to purchase a property from Mr. Olok Dotto. My lord, the demand draft shows that the money was duly received by him. My lord, Mr. Olok Dotto has not been made a party over here. My lord, he will be a person to say that whether he has received the money from Shubhadev Mitra's account or not.
That's for the police to
Well, that is,
question all of that. Because
well,
I
their
don't even
SC case,
know
my
it.
lord, it is for the police, my lord. What will the bank do?
My lord, also the petitioner number.
See, there are several disputed questions of facts, and it will not be proper for the writ court to enter into
my
all
lord,
these things.
Just for once, if your lordship may be pleased to pass an order of certiorari, let the originals come.
Original of what?
Original of the title deed, original of the form which was submitted, and the verification form of the bank. Because it's in a bank, when an applicant makes an application for loan, he has to submit an application with a photograph. Then they have to visit the two places. One is the viability of the applicants, loan applicants, borrowers, background, and his collaterals. So his house and him in front of his house, that is Kodamtala address, there must be one photograph, original photograph with the bank. And then with the new property, which the bank will also go and inspect. So, my lord, this will be with their records, with the Punjab National Bank.
My lord, not necessarily. Here he is purchasing a property, my lord. For that he has taken a loan, and my lord, he has submitted the title
What
deed
is
of
the
that.
what is the title deed that has been mortgaged with the bank?
My lord, that is the deed of conveyance that the purchaser
property.
is a new property. My lord,
Not
new
the
property,
old one.
not the old one. My lord, how will the bank be having the pictures with that household? My lord, it is not possible.
The new
for the
house
bank.
is also not yours?
No, lordship.
New house is also not.
The Kodamtala nor
The
Maheshwara.
police will be the appropriate authority to decide based upon the documents, my
Did
lord.
you lodge any further complaint before? Did you lodge any complaint before the police?
No, your lordship. We have just given, filed an original application for recovery. Upon getting the service, my lord, they have come up with this writ application. My lord, prior to
Because-
that, order from the ombudsman was passed back in the year of 2024. My lord, no writ application to that effect. My lord, they have served the police authority with a complaint in the year of 2024. My lord, no police in action therein. My lord, only after receiving the copy of the original application, my lord, this has come. Kindly cease to the press see once.
Now tell me, is the person to whom you have disbursed the loan repaying it?
No, that is why, my lord, the loan
become
account has
NPA.
become NPA, and my lord, we are proceeding towards our recovery.
In the
My lord,
loan-
in
So
this,
somebody
bank
has
is also at
taken
stake.
somebody has taken the bank for a ride.
Yes, I
So
bow down
bank
to that.
should take steps.
Yes, your lordship. We are agreeable with that, but the police has to decide, your lordship. We
No,
can.
but then you should approach the police. The
We
police will not interfere with suo moto.
We will, your lordship.
Stopping
At the end
you.
of the day, they will come
Act
after me. My lord, even if your lordship takes up the loan agreement, the agreement for loan, the address is still 99 Ramakrishna Polli,
Which is not yours.
not mine, lordship. I have got no connection with Howrah or even Behala Maheshwara.
Then it can be said that somebody of your bank has entered into a collusion with that person and got that loan account, has allowed that loan.
My lord, I do not believe so, my lord, because address are all verified from the documents given. There has to be some documents
Then
which shows.
produce all
Well, we'll
records.
produce the originals. Will whatever do we have?
Achha. What is the loan account number?
Lordship. Loan account. One second.
The petitioner has prayed for issuance of
Page 37.
writ of certiorari. Stop. এইটা তো এই যে ডাক দিয়ে দিয়েছি learned advocate representing the bank is directed to produce all the original documents relying on which the bank disbursed the loan amount in account number such and such in the name of one Shubhodip Mitro, page 37 এ আছে ঠিক আছে let inspection of the originals be given to the learned advocate representing the petitioner at a mutually settled date, place and time. Release the matter for further consideration on 18th of June.
I'm grateful.
The report filed by the police.
That will be taken on record.
Lordship, one more thing, my lord, last occasion I had not submitted my affidavit of service.
Inquiry is taken on record.
My lord, what fell from your lordship is more like the Nirav Modi case, where everybody inside the bank was involved.
Maybe, otherwise it could not have been if your version is taken to be correct.
My lord,
Next.
I will still support my version. I'm grateful, lordship.
Grateful to you, Lordship.
The petitioner, my lord, led by Mr. Ratnakar Banerjee, my lord, is in some difficulty today. The interim order is expiring tomorrow. If it can be taken up tomorrow, my lord. Tomorrow, I'm only praying, seeking a not today, my lord.
The business of the court will not permit the matter to be taken up tomorrow.
My lord, the interim order expiring tomorrow, my lord. That's the difficulty, my lord. We are taking steps, my lord.
Let me see. The interim order is restraining the respondent from taking against the flying of the ship. What is the stand of the authority
for issuing and issuance of document of compliance?
Yes.
It is in
The discussions are going on, my lord.
Discussions are going on. Now, in the meantime, we prepare a supplementary affidavit
yes.
to the effect that, if your lordships kindly remember, last occasion Mr. Banerjee told before submitted before your lordship that this audit, this is not a memo, this is an auditor's report, auditor's observation that has been annexed, and one more document. In the year 2002, there is a circular.
Can the court adjourn the matter for you all to take discussion?
Can I please allow me to?
Yes, please.
Because last time you told us to take persons to come.
Yes.
That's the reason we have come here.
Yes.
He is Mr. Sajendra who has attended the audit, who has given the measure non-conformity.
Yes.
And he is another surveyor who has attended the inspections on board vessels and all investigations also. I was also one of the surveyor and lead auditors for the
yes.
and some of the vessels we have attended.
What do you all notice on the at the time of audit?
Regarding this DOC ke there is an ISM code is there, international regulation. The DOC is issued a basis on that. Okay, now whenever the measure non-conformities are there and what action has to be taken, it was categorically spelled out. So it is not that you have complied partly that DOC is issued as per this one there and one measure non-conformity is achieved and we started approaching the courts and seeking the time frame. Is it allowed that the point has to be taken into account, ma'am? This is the international code of regulation. This is a statutory requirement which need to be complied with. And all the nationalities, all the countries have ratified this. Even India is a party to the SOLAS regulation. It is a mandatory requirement which need to be complied with.
Is the petitioner not complying with it?
That is the reason they are not complying with. Please.
What exactly is to be complied?
So whenever a DOC, when measure non-conformities are appeared, and when a DOC was not renewed, then automatically the safety management ships on the ships also gets expired.
All right.
So that and all vessels cannot ply. Immediately it has to be put over a stop.
It has to be grounded.
It is categorically spelled out there. Please
all right.
see that section.
So because of the court's order, the ship is flying.
Yes, that is the reason.
And anytime any accident can take place.
See, considering the history, And no insurance will come if any incident happens
insurance
because
will also-
certificates are got expired. That is one of the point. Another thing is that if you consider the past history and accidents of the particular company, which is running only 3 vessels, not basically only 3 vessels are flying. When was the incident? 2017. There is a one vessel which has
Capsized.
sank.
Hmm.
And 2023 there is one vessel which collided with the Coast Guard vessel.
All right.
And 2023 they are the ITT vessels. And in 2023 there's one more vessel which has stuck with a dingy boat at
All
Port
right.
Blair, and the FIR complaint was there. Recently, in few days back when the court hearings
So what
are
do you
going on, one
propose?
vessel has listed to certain vessel.
Right.
Court has stopped the passage of the vessel.
What do you propose right now? Do you all propose to continue with the talks so that it can be
The
settled?
DOC is withdrawn. That is, as on now, it is already withdrawn.
It's
And
withdrawn.
so whenever the DOC gets withdrawn, automatically the SMC gets withdrawn. That is what the statutory regulation has says it.
Page 7, your lordships kindly see.
See, only because of the court's order that you are plying your ship.
Yes.
Now, if something happens,
That's why I'm saying, my lord, kindly keeps it tomorrow. My interim order is till tomorrow. I'm not saying keep it day after tomorrow. I'm kindly keep it tomorrow. Mr. Banerjee is here. He's leading me, my lord. He'll answer all the queries, my lord. It's only not tomorrow, my lord.
Not
Interim order is
today.
till tomorrow. Not today. I'm
all
saying
right.
only not today.
On the prayer, record an order on the prayer of the learned advocate for the petitioner. The hearing of the matter stands adjourned for the day.
May I request?
Please record the presence of these people. They were heard.
3 of us.
And it has been submitted. And it has been submitted that as the document of compliance has been withdrawn, the ship ought not to run, ought not to ply. Stop. In the event any untoward incident happens, then the ship will not be covered by any insurance.
May I file my affidavit and reply to writ petition?
The petitioner is required to obtain the document of compliance immediately. This is what is to be done.
Yes.
Document of compliance has to be taken.
Discussions are
Yeah,
going
withdrawn.
on.
Withdrawn. As of now, it is withdrawn.
As of now, withdrawn, but this is what is required.
Yes,
Document
required.
of compliance for plying the ships.
Yes, correct.
The discussions are going on, my lord. We've had Zoom calls with the DG shipping, my lord. That is also
Whatever.
attached in my reply. May I file my affidavit and reply, my lord? It's a voluminous document, my lord. May I file that?
Affidavit in reply to what? Where is the
To the writ
opposition?
petition, my lord. To the writ petition, my lord.
Reply to the writ petition, reply to the opposition.
No, opposition, they are to file, my lord. My writ petition.
Yes, opposition. See the volume of the opposition, see the volume of the writ petition, and see the reply. What have you annexed?
My lord, all the rules, the ISM rules that my learned friend is referring to, all
That
these,
was a very small book.
there are other rules also which are there. So far as the guide of seamen are concerned, every rule is there. My lord, as also, my lord, all the documents that we have submitted thereafter, the filing of the petition, all these documents, that's why it has become a very voluminous document, my lord.
Ma'am, can I speak?
I have served them a copy of the affidavit.
If you allow me, ma'am, please, can I say so? Ma'am, this DOC is issued based on this. So, and it is not that we partly comply with this, and later on when measure non-conformity is issued, what has to be done, this has categorically spoken. So we have to comply in totality, madam, with a certain statutory regulation is there. Whatever order you are giving, we have to comply with full in that.
It's all right.
Supplementary
Affidavit by the respondents. Now you'll file another rejoinder to the supplementary. Taken care of.
it. However, we are also seeking leave to file if required, my lord, if necessary.
Were
They are
you-
pleading in my reply.
Were you aware of the supplementary when you
Yes, madam.
prepared?
Yes, sir. Yes,
Then
sir.
it is all right.
Yes, sir.
Tahle aar kichu na hai. Only
May I file
supplementary.
affidavit reply,
Yes,
madam?
reply. Reply to Nevin.
Well, may the matter retain its position, madam. That's all I'm seeking. May it retain its position. I'm grateful. I'm grateful.
ওনাদের appearance গুলো record করে নিয়েছেন?
37, your lordship was pleased to call for a further report. If your lordship is state, my lord, I'm being led by Mr. Mohan Ghosh. My lord, there was a direction upon the BLLRO to produce a fresh report regarding the queries whether the mineral rules are complied or not.
Whether the
mineral rules are complied or not, madam.
Yes.
My lord, sand rules, no? And
Yes, yes,
that
then.
rules are complied on. My lord, we have received a report, my lord, but according to us, it is very inadequate. It doesn't satisfy the query of the court, my lord. So I seek further time to file a report.
Well, Lordship would kindly consider they are serving us notice to participate in the hearing in the inquiry. The date of the inquiry is fixed on 29th of April 2025 at 11 a.m. The notice are being served upon us on that date at 6 p.m. You will kindly see this is the postal.
This is the speed. This is the speed by which they are working.
Everything got infructuous. Then the participation is. Lordship would kindly see this is last.
All right, please come.
Same thing happened.
Learned advocate representing the state respondents seek extension of time for taking instruction. Stop. Learned advocate representing the petitioner submits that the notice of inquiry was served after the time for inquiry expired. Paragraph. On the prayer for adjournment made by the respondents, hearing of the writ petition stands adjourned till when? 9th June.
I'm appearing on behalf of the petitioner. Matrimonial petitioner had two multi-benefit old age deposit received with the respondent bank amounting to rupees 40,000 and 10,218. Total amounting to rupees 50,218. On the last occasion, your lordship was pleased to direct the petitioner to produce the original before the respondent bank, as they submitted that they could not trace the deposit, the slip. That has been deposited, and an amount of rupees 55,308 has been dispatched in the account of the petitioner on last Saturday, my lord. But the amount which was actually deposited in 1983, it was 50,280. Although the petitioner claimed for compound interest, even then, my lord, calculating simple interest, this amount cannot be made. My lord, kindly direct them to file opposition. They have not given any breakup or
no opposition. Only the breakup is required.
May I indicate only one thing?
Yes.
There were two FDs. It's in physical form. In the old days, there's FD. It was very candid for the bank, for me at least. It is fallen from me only. Despite the fact that it is not of our branch, I said it is being the Punjab National Bank. College Street branch manager is also here present. So I said whatever branch it is, will pay. Old or new, forget about this. So very candidly, I submitted the last.
Which branch was it?
Zakaria Street branch.
Zakaria Street.
Now College Street action. Give me a second. So College Street branch has been made a party to this. It is candidly fallen from me that despite from any branch, we'll pay that. Now kindly see, this is the original one. The branch.
What was the rate of interest at that point of time?
Can you see the back of it?
Yes.
Then middle of that.
Middle.
10%. I got it.
Yes, 10%.
Now can you see the front of it? The last line payable after
12 months.
For 12 months, this FD was made.
Right.
It was not renewed thereafter.
Auto renewal is not there.
Nowadays, the auto renewal because
that point of time there was no auto renewal.
Unless you mandate it.
All right. And in 82, did you not produce this receipt?
My lord, what?
83, it must be 1 year.
My lord, it was produced, but
83?
showing the pendency of the, yes, my lord, showing tendency
from 83 till 25.
My lord, yes, my lord, I have annexed the order sheet, my lord.
Order sheet of what?
Showing a pendency of a criminal case. My
assuming.
Lord, has not been.
Assuming. But then why will the bank be liable to pay extra interest?
Transaction between the petitioner and bank is a commercial transaction. They have not.
What commercial transaction? You have made a fixed deposit. Fixed deposit there, and it will not inure to extra interest.
My lord, they have not kept the money idle, my lord. They have.
Sorry, madam.
Business.
They may have utilized the money. Are you entitled to it?
My lord, kindly give them, direct them to give the breakup. Otherwise,
what breakup? 10% interest for 1 year. How much will you get?
My lord,
10% interest in a year. How much will you get?
My lord, at that relevant point of time,
you will get that only. My lord, they are not going to get anything extra. My lord, 40,000. Another was 10,280. Whatever it is. But kindly direct them to give the breakup. Otherwise, the petition, only the amount has been credited to the account of the petitioner. After 41 years, my lord, 50,000. It is not after 1 year. The bank did not hold it like that. The fault is the case was pending due to the then manager of the Punjab National Bank has defaulted some amount. For that reason only. A learned advocate for the petitioner admits that a sum of rupees 44,000 and a further sum of rupees 11,308 has been credited in the bank account of the petitioner. Stop. It has been submitted that the rate of interest which has been paid is extremely low, and the bank withheld the money since 1983. Stop. Learned advocate representing the bank has produced the original fixed deposit receipt to show that the fixed deposit was payable after 12 months. Fixed deposit, the matured amount on the fixed deposit was payable after 12 months at a simple interest of 10% per annum. Stop. There was no provision to renew the fixed deposit. Stop. It has been submitted that the bank is not required to pay any additional interest for the said amount. Stop. Learned advocate for the petitioner seeks breakup of the amount that has been paid. Stop. Let a copy of the same be handed over to the learned advocate for the petitioner. Acha, a copy of the same, a copy of the breakup. A letter copy ta kete din. A copy of the breakup of the amount paid to the petitioner has been handed over to the learned advocate for the petitioner in court today. Stop. The grievance of the petitioner appears to have been redressed. The writ petition stands disposed of. My lord, kindly note my submission, my lord. I have recorded your submission. This amount cannot be paid after 41 years, my lord. 50,000 is coming to 55,000, my lord. Kindly note that. Kindly note my submission, my lord. I have recorded it and I have dealt with it. The grievance has not been redressed, my lord. Only that.
Deeply obliged. I'm grateful.
But I take to appeal from the respondent back.
Lord, this is my
Last
application.
occasion when the copy has been served upon me. Now, my lord, the
I think
grievance before your
40
lordship,
টা
my
কি
lord,
হয়ে গেছিল? 40 টা সকালবেলা হয়ে গেছে। 41?
the grievance, their grievances, my lord, they have entered a settlement with the bank. Bank has to return the 3 deeds, my lord, pertaining to the mortgage, my lord. Now, it is their grievance before your lordship. Now, my lord, I have 2 arguable points before your lordship, my lord.
Let me understand from the petitioner.
Yes.
What is your case?
Chief, there was a loan. Loan was taken by the petitioner company. My instruction is that it was settled sometime in 2018.
But the title deeds are not returned.
No.
All right, let me hear. Yes.
Kindly come to page 13. They have annexed, my lord. Their first representation, they are claiming that, my lord, the matter got settled, loan gets settled on 18/8/2018, my lord, with United Bank of India. Now, my lord, the first representation, my lord, the month of February 2024. Now, my lord, they have annexed everything except a no due certificate. Till that date, my lord, I'm trying to ascertain from the bank, my lord, there is no due certificate, my lord, in the file. So, my lord, I am praying before lordship, my lord, can you direct them to produce the no due certificate? If at all they have settled the amount.
Show me something from where it can be ascertained that your account has been settled.
Lordship, whether the payment made to them, the account statement, and my lord, I'll produce that. Let me file a supplementary effect.
Why did you not file it with the writ petition? If your case is that your account has been settled, your loan amount has been liquidated, you ought to have filed it with the writ petition.
Lord, the thing is that we have been sending them representations. There hasn't
Without any supporting document, sending representation will not help.
and they haven't replied to us even.
Somebody goes on writing letters after letters and the bank has no work, will go on giving reply to your letters.
Yes, maybe my lord, they have approached in the settlement, but it is not got
The
taken
petitioner
place.
claims
My
that
instruction is that it was
the loan account of the petitioner
a demand from
has been settled, but the bank is deliberately not returning the title deeds. Stop. Learned advocate representing the bank submits that there is nothing on record to suggest that the loan accounts of the petitioner stood settled. Learned advocate for the petitioner seeks time to file supplementary affidavit. Annexing documents to show full stop hobe na okhane that the loan account stood settled. Stop. As sought for, a supplementary affidavit may be filed by
My lord, upon reopening,
13th of June. List on 24th of June. Instruction shall be taken by the learned advocate for the bank prior to the adjourned date.
My lord, I am for the WPDCL. I am led by Mr. Advocate General, Learned Advocate General. He is out of station. My lord, kindly make it not today.
What is the matter about?
They allege that while mining, their buildings were somehow
Damaged.
Yes.
What is it?
Exception, my lord.
We will give. Exception to the report filed by WBPDCL.
No,
by the petitioner, my lord.
Exception to the report filed by PDCL.
We are for union of PTM, you get a copy.
Exception of the petitioner. Exception of the exception filed by the petitioner to the report filed by WBPDCL in court today is taken on record. Stop. An accommodation has been sought for on behalf of the learned advocate general. Stop. On such prayer, released on 17th of June.
My lord, I am appearing for the private respondent, 2, 3 and 4. Private respondent, 2, 3 and 4.
This matter ought to go before the civil revision court. This has been adjourned. That elderly lady was there on the last occasion.
That order was passed by his lordship.
Yes.
That is an order challenging an order of the tribunal. That's what his lordship's view was, that it has to be sent before the divisional court.
My lord, no development yet. Lordship may kindly.
Civil revision is pending. Civil revision is pending. Degi, CO 4034. 4034. 4032.
3 civil revisions altogether.
Oh, 3.
3 revisions. In one order sheet, analogous, my lord.
Acha. 4034.
Lordship, more so, this writ application is challenging the order of the Honorable.
Please come. The petitioner is not represented. Stop. Learned advocate representing the private respondent submits that the civil revision application is still pending. Stop. In view of such submission, the writ petition is delisted for the time being. Liberty to mention on conclusion of the civil revision application.
My lord. Value.
My lord, I am for respondent number 6 and 7.
44, my lord, due to the personal difficulty, my lord, my learned advocate on record, my lord, could not attend this honorable court.
Who are you appearing for?
My lord, I am for petitioner, my lord.
Petitioner.
Yes, my lord. My lord, I am only praying for not today, my lord.
My lord, as per my lord's direction on the last occasion, they have paid me the maintenance for 2 months, March and April. As per tribunal's order, then my lord, now it is stopped from May.
And my lord, thereafter, my lord, your lordship was pleased to keep the matter under the heading, my lord, adjourned motion.
Yes, it's
It's
appearing.
appearing.
Yes, my lord. My lord, I am only praying for not today, my lord.
Only praying for not today.
Yes, my lord.
Where is, why are you not paying the money?
My lord, I have already paid the money, my lord, for in
Only
terms
for
of the
March and
order passed by your lordship, my lord.
March and April.
March and April.
Yes, my lord.
It is
In terms
due
of the
from last
order
September.
passed by your lordship.
This is due from September, from the order of tribunal.
Any appeal preferred?
Yes,
No, they have preferred this writ petition.
Any, no
my lord,
appeal?
appeal has been preferred, my lord, but the copy has not been received by the concerned authority, my lord.
Yes, that is the reason. Money has not been paid.
Page 66 is the order of the tribunal.
আচ্ছা আসুন তো দেখি learned advocate for the petitioner seeks adjournment. Stop. Learned advocate representing the private respondent submits that the maintenance amount for the months of March and April have been paid, but no money for the month of May has been paid till date. Stop. The maintenance amount is due from September 2024. Stop paragraph. On the prayer of the learned advocate for the petitioner, hearing of the writ petition stands adjourned till 17th June 2025. Stop. The petitioner is directed to pay a further sum of rupees 16,000 in the bank account of the private respondent for the months of May and June 2025 prior to the adjourn date.
Yes, 19.
In this matter, I am appearing on the respondents number 4 to 7. In spite of your lordship's directions, filed my appeal.
Is the petitioner there?
You are directed to file the except for our response. We are filing the report on it will be formal immediately.
That is your last order on 10th April.
Was any has any steps been taken before the tribunal?
No.
No. Acha, affidavit filed on behalf of the respondent numbers 4 to 7 in court today is taken on record. None for the petitioner. Petitioners. Writ petition stands dismissed for default.
My lord, I am appearing on behalf of respondent number 1 and 2, my lord.
I am appearing on behalf of the respondent number 3 and 4, led by Mr.
Well, I am appearing for response 6, my lord.
My lord, kindly see the lordship's last order, my lord. The petitioner,
Nobody is appearing for the petitioner.
the party was appearing.
Which Mr. Patil? Nobody appeared last time?
Yeah, last occasion, get the opportunity for to appear today. But there is some mistake in the last order passed by your lordship. The manager, your lordship's observation is that manager has resigned from his post, but it is should be clarified, my lord, because he has resigned from the highest designated.
I am for the manager. I am performing my duty as manager. I resigned.
Not resigned.
I resigned for the as a highest designated post, my lord.
আচ্ছা ঠিক আছে. None for the petitioner. Stop. Learned advocate for the Respondent numbers 1 and 2 submits that the respondent number 6 has resigned from the post of the highest designated officer and not from the post of the manager.
Highest designated employment.
Acha, highest designated employee. And not from the post of manager as recorded in the order dated 16th April 2025. ঠিক আছে. The recording in paragraph number 2 of the order dated 16th April 2025 is corrected accordingly. Stop. The writ petition stands dismissed for default.
One thing, at present, my lord, the board is performing as usual, my lord.
Let it perform.
But in fact, my lord, the expression what they have made literally also not correct, because highest designated employee is also, who is the highest designated employee is the manager. Therefore, both
Manager is the highest designated.
Synonymous. He has resigned. It is not correct. Be that as it may, they are saying. Lord, I appear for the register lordship.
Lord, I'm happy for the petitioner. Lord. May I file the exception to the report that my land friend has filed?
Lord, I am appearing for the Jilla Parishad, my lord. In compliance of your lordship's direction, my lord, may I file my report, my lord? My lord, may I file my report?
I file the exception as the lordship. But may I tell you, lordship, the facts are very short. But the actually we are challenging at the moment, Lord, before your lordship, that I have been blacklisted. Petitioner 1 has been blacklisted without notice, without so cause, without anything. Sadly, we received a letter that you have been blacklisted. So the reason is this, Lord.
Order of
What has happened here? Well, there was a tendering process by my land friend's client. 7 works have been allotted to us. All have been completed. 6 they have made payment to us. Final bill has been paid to us. And so far the 7th one is concerned, this was completed in 2024. Nothing has been paid to us. So we have been running to them, writing letters to them. None of them have been replied to. The reason I will just read a couple of lines from the letter which my client has written. Now, what has happened in the meantime? They have lodged an FIR, GD against us, alleging that the SAE has been, substitute engineer has been, contractual substitute engineer has been physically assaulted. But that's not the police report at all. Well, I'll come up to everything now. But what was the reason? That we have been approaching to them every day. If your lordship for a moment takes up my writ application.
But I do not see any blacklisting over here.
Yes, yes. The letter is there, Lord. Lordship, kindly come to the letter, their letter. That's at page 26, most probably. Lordship, kindly bear with me.
Janabu? The 1 minute, a wrong file was handed over. And that is the reason I was hunting.
Sorry, Lord. So that is
25.
Yes, page number 25.
That's the blacklisting, Lord.
Now I
Lordship, kindly file it. This 12th of March 2025, we received on 19th of March, 18th of March. Whereas it has been reported by Sri Sudeep Kulbe SA Contractual so-and-so that you had physically assaulted him on 4th of January 2025 due to reason better known to you. Whereas a GD has been lodged by Sri so-and-so at police station number so-and-so dated 6/1/2025. Whereas the same matter was being discussed at the PKO PSS as held on 27/1/2025, and as per decision taken in the said meeting, in the context your agency has to be blacklisted from all kinds of works under Nadia Jilla Parishad. Now, therefore, according to decision, I am directed to inform you that you are hereby blacklisted from all kinds of work from Nadia Jilla Parishad for 1 year with effect from 27 January 2025. Now, Lord, kindly come up. What was the reason? But the reason is that, Lord, there is a caucus formed in the office of the Jilla Parishad to oust us with the league of certain contractors. So naturally, there was a demand of 5 lakhs of rupees as a bribe, so that the final bid could be prepared and paid to us. Lordship, kindly come to this, a daring letter. Probably my client has written it. But Lordship, kindly come to
see when the report is there and exception is there, then we'll hear the matter and then finish it off. At this stage, it cannot be done.
May I tell you, Lordship, what was the reason? But today, exactly the Supreme Court has used the word civil death.
It's not a death under the criminal procedure code, but it's a death under the civil procedure code, or rather civil death what the Supreme Court is used to. Today, I am not getting anywhere. Because once blacklisted in Jilla Parishad, I will not get any work in India, far less in West Bengal. That's what now the scenario is this. Apart from that, on 10th of January, they have issued a work order in my favor. That is, though of course they received after this letter. In the meantime, they have also entered into an agreement. Now the agreement, they are saying proceed with the work. But they are saying now I can give you the site.
I cannot.
I cannot give you the site because blacklisted. So I'm cut from the head, I'm cut from the tail. That's the scenario they've created.
Base 33.
And my amount of 70 lakhs, maybe I'm exactly not giving the figure. The 70 lakhs of which the bail they have prepared. So bail very recently prepared after all these reports and everything now. So the bail shows that have completed that work also. The report has twofold submissions. One, they are saying, but I know Lordship has a fixed matter at 4:15. But I'm just taking 1 minute's time so that Lordship can fix a date for this also. Now, one point that they are taking it, that you have not completed the work of 36 units, 33 units you have completed. But I have also an previous completion. All 33 units they are taking it to complete it. Because the reason is this, that the amount when the final bill is prepared is touching almost clear about the final bill. Sorry, contractual amount. Now, if further work is to be awarded to us or given to us, the site has to be given. No site has been given. I have written so many letters. Not a single letter has been replied to by them. So I am handing over the site. Now that they have reached this final bill amount, they cannot pay us out because they will have to further sanction further amount. So nothing will ultimately come out of it. That was the reason. They have not replied, but no point was taken at any point. Second point that they have taken.
But then this will be hard. This will be hard after the vacation. What can be done? Now it cannot be done.
I know is
no so-called notice.
Nothing has been done. Hand over to your Lordship, the very recent Supreme Court judgment.
No, it's all right.
That this cannot be done at all.
What about the pending bills and everything?
Lord, pending bills, my lord, I have no knowledge. My lord, he submitted before your lordship just now, he had supplied 36. But if your lord...
33.
33 out of 36.
So, my lord, he has not completed his job. So far, others is there, here on there, it is not the part of this writ petition at least, my lord. I am not on that. So, I am on that, my lord. He has beaten someone and investigation is going on, and main gist of the reply is this, my lord, I have got from his reply that, my lord, 5 lakhs rupees. My client, not my lord, the officer of the Jilla Parishad, my lord, offered him to give some bribe. But it is the total, my lord, stage of his case. Now, my lord, kindly take the reply of the state government's instruction. Kindly take, sir. State government instruction, kindly come to page 3, my lord. State instruction, page 3. My lord, it was kept on record last occasion. It was a police report. So, my lord, kindly see, my lord. It is, my lord, from, I am reading, my lord, first, second, third, fourth, fifth, sixth line. Right hand portion, sixth line. It is the government's report. It's not my report, my Jilla Parishad report. When the information demanded the bill, the alleged person asked for a bribe of 5 lakhs rupees. It is his complaint. On the basis of that, police give report before your lordship. What the report says? My lord, it says, my lord, second paragraph. It is the main allegation.
So what is the use of going into this? He is challenging the blacklisting.
No, my lord, no. He is the gist of his reply of my report. If your lordship go through his report, my lord, to his reply, he is saying that all has happened, but my lord, everything has happened due to want of bribe. But my lord, police says, my lord, no such incident was happened on that date. Petitioner made a false allegations against the OP member. It is the report, my lord, of the police. So, my lord, he is defending himself by saying that, my lord, the officer of the Jilla Parishad, my lord, sought for bribe from the petitioner. But police says it is not correct. So, my lord, his reply cannot stand. So, my lord, my report is, my lord, it confirms, police report confirms
the report
my
of
report,
the respondent numbers 1 to 4. And the
he
exception
is
there
taking
too,
false statement before
filed by the petitioners,
The state has not given anything to me.
are taken on record.
আপনিও তো স্টেটকে রিপ্লাই দেননি আমার
The
reply।
matter is required to be heard.
If your lordship kindly look into the annexes I have given, the police report, which I obtained through this Right to Information Act.
Yes, I'll see it on the next day. List on
My lord, report may be kept on record.
13th.
13th of June.
Yes, yes. 1-3, first Friday after the vacation.
My lord, 13th
Kindly
June.
protect me because they are not giving the site to me and they will blacklist me on that ground also.
My lord,
That is not the prayer in your writ, isn't it?
But this has recently come up now.
Then something else. Something else.
After that, after this petition, they
Then
went
something should have been brought on record on which the order can be part.
the letter that a work order that was acceptance letter that was given to me that have annexed. But except letter of acceptance, nothing was done. Now, in the meantime, they have entered into agreement, called upon us, signed the
And that's an absolute different cause of action.
A copy should be given to me.
my lord, instead of 13th, my lord, kindly take it up on 20th, my lord, next Friday, my lord.
Why? He is suffering
13th, my
civil
lord,
death.
On 13th, my lord, I have some personal difficulty. I have a doctor's appointment. My junior will be there.
You let your junior remain.
My lord. I will try, my lord, but my junior will be.
সবগুলো কিন্তু উইথ করে আছে, এখানে আছে কিন্তু অর্ডার আলাদা।
It's
What has
very
happened?
urgent. Mr. Bhattacharya is also here for the respondents.
Yes. What is the urgency?
Yes, my lord, when I moved these applications, this bench was not available for obvious reasons, my lord, so I assigned to Justice Kant. So when I moved this application, my lord, I submitted, this is the urgency. My lord, Justice Kant, shortest time for filing affidavit and date was fixed. With the understanding that I will not, for the timing, I will not ask for interim order. My lord, everything is complete. Now it is a constructions job, my lord, and in spite of the fact they did not comply the or the do not have any requirements appropriate, they are obliged. I just stated everything in my petitions, and reply has also given, affidavit has been given. So, my lord, they will go on towards the time-bound work.
Proceedings are
If it
complete.
is
Today in the morning, your lordship declined to grant relief in a matter, my lord, where work order was issued. Here is also a similar matter. When the matter was moved, my lord, work order was issued. In terms of the tender clause, they were supposed to, within 48 hours.
Well, I'll argue that, my lord. Let me start then.
Within
The
40
same,
No, listen,
same plea
if-
was taken, that was not accepted by Justice Khan.
If
That
the
doesn't mean,
pleadings are over, then
My
it
lord-
is to be heard. If
my lord,
pleadings
that
are
is why
over,
it is fixed. My lord, Justice Khan, considering the urgency, 2 weeks, only 2 weeks.
Insofar as
All
my
things are-
affidavit
and
does
a
not use the
all
response.
affidavit is complete, and particular date was fixed. So that
no,
is-
but then it's already 4:31.
No,
You
no, I-
want the hearing to be taken now?
No, at the end of the day, I cannot disturb your lordships. But
No, not disturbing. The court hours are over.
That's why I cannot disturb. Kindly hear me.
So
At this stage, I cannot.
what?
But kindly oblige us, my lord, because let the matter be heard. If it is not possible today, tomorrow, and day after tomorrow, kindly fix it, my lord.
Day after tomorrow?
Yes, fixed.
Very well. Where is your opposition?
My opposition.
Here is a reply given in by.
They have not used a reply to my opposition.
Whose reply to what?
Reply to the affidavit, to the writ petition.
Whose reply is?
He is filing the reply to respondent number 5.
5 and 6.
And I was
Respondent
6.
number 6.
Both 5 and 6. Both.
The 6 affidavit then.
This is unfortunate. This is utterly apology. I'm being unconditional apology. Anyway, he's getting time. He's an expert, my lord. 1 day is enough for him. Since my lord is fixing on day after tomorrow.
When I'm pitted against Mr. Banerjee, I cannot remain an expert. I'm just a fool. I'm being led by Mr. Vikas Ranjan Bhattacharya. Kindly.
Affidavit in opposition filed on behalf of the respondent number 6. Is 5 also filing an opposition?
5 is not here apparently.
Then
I
how
just
is
served the copy.
that means copy must have been served?
Yes.
I filed the reply.
Because this is the reply. Achha, respondent number 6 and the reply there to file the petitioner. Filed by the petitioner is taken on record. Stop. A reply of the petitioner to the opposition by the respondent number 5 is also taken on record. However, the original affidavit in opposition of the respondent number 5 has not been filed in court till date. Stop. Learned senior counsel for the petitioner. Praise for fixing the matter for hearing on Wednesday, 21st. List on 21st. For hearing.
Here, ma'am.